I don't see Representative Newman yet either.
Okay.
All right, you're ready to go.
Okay. Good morning. I am Senator Joe Baldacci. I'll be presiding over this work session of the Joint Standing Committee on State and Local Government. The format is new to all of us, and we expect that there will be unforeseen glitches and mistakes, so please be patient. The purpose of this meeting is for the committee to receive information from staff and others in order for members to consider the legislative proposals before them and make recommendations or reports to the legislature. Only committee members, the committee analysts, and those specifically invited to attend will be participating in the work session using Zoom. For members of the public wishing to observe this meeting, it is being live streamed on the committee's YouTube channel and will also be recorded for viewing after this meeting is concluded. We are also broadcasting the audio of this meeting on the legislature's website. The YouTube live stream of this meeting is accessible to the public, begins at the scheduled start time for the work session, and will remain on until the end of the day's work. If your video or audio is on, even if the committee is not then in active session or is on break, the public can see or hear you. Please remember to mute your microphone when you are not speaking. Please check to be sure that your name appears correctly on the Zoom screen. This is a public meeting, and I must remind you that while we are meeting, discussion must happen on screen and not by way of the Zoom chat. You may use the chat to request to speak or to indicate that you are having a technical issue or to indicate that you are momentarily stepping away from the screen. However, again, you are not to use the chat feature for substantive discussions. If you're having technical difficulties, please contact the committee clerk who will try to help you. So members will speak with the leave of chair. Materials will be provided electronically for this meeting. When it comes time for the committee to vote, we must have a quorum present, at least 7 members, including a senator. In order to be counted as present, your identity must be visually verifiable on the Zoom screen. I will now call on members to introduce themselves, starting with Representative Lynn Copeland.
Thank you, Mr. Chair. My name is Lynn Copeland, and I'm proud to represent the folks in House District 14, which is downtown and coastal Saco. Welcome.
Great. Good morning. Representative Randall Greenwood.
Good morning, and thank you, Mr. Chair. My name is Randy Greenwood. I represent House District number 82, which are the towns of Litchfield, Monmouth, and my hometown of Wales in both Androscoggin and Kennebec counties.
Great. Representative Walter Reisman.
Thank you, Mr. Chairman. My name is Walter Reisman, and I represent District 69, which is Bridgeton, Harrison, and Denmark.
Great. Good morning. Representative Francis Head.
Thank you, Mr. Chair. My name is Frances Head. I live in Bethel, Maine. I represent District 117, 23 towns and townships in Oxford and Franklin County. Thank you.
Great. Representative Kathy Downs.
Thank you, Mr. Chair. Good morning, everyone. My name is Kathy Downs. I represent District 130, which is Bucksport and Orrington. Thank you.
Great. Representative Mark Bryant.
Thank you, Mr. I represent House District 24, part of the town of Wyndham. Good morning.
Good morning. Representative Donna Dorr. Representative Dorr, you're
Good morning. I'm Representative Donna Dorr. I represent District 85, which is a portion of the great city of Augusta.
Great. Representative William Toole.
Good morning. I'm Will Toole. I represent the Machias area plus Lubec and Eastport.
Good morning. And my co-chair, Representative Ann Matlack.
Good morning. I am Ann Matlack. I represent House District 92, which includes the communities of Cushing, Thomaston, South Thomaston, St. George, Matinicus, Creehaven, and the Musselbridge Islands.
Great. And my name is Joe Baldacci. I represent State Senate District 9, which is the city of Bangor and the town of Herman. So I will now open the work session on, is Senator Claxton here?
I don't see him on the
list.
Yeah.
Senator Carney's here.
Senator Carney is here. Yes.
Okay, we ought to bring Senator Carney in.
And again, I don't see Representative Newman, so, but I
Yeah,
did
I think there's
send
a couple, I think there's a couple of roads related people in the attendee list that should be brought in.
I have Carol Leopold, Kate Knox, Nikki Tebow, Rebecca Graham, Roberta Mantor, and Tom Doak. Do you want
Okay.
any of those folks?
Yeah, I don't think Kate Knox is here for these, but maybe she is. I don't know.
If I may,
Go
Mr.
right ahead,
Chair,
Lynn.
I know that Rebecca Graham, Roberta Mantor, and Tom Dokes are
Okay.
probably here for all the bills.
Ms. Knox is here for this bill.
Oh, she is, okay. So
Kate
then
Knox.
just to have them come in then, I guess.
Thank you. Lynn, did you say Tom Doak as well?
Yes, Maine Woodland woodlot owners.
Okay. There you go.
Okay. So we're going to be doing LD 596, 806, and 1513. And we can let the sponsors of those bills other than Senator Carney in when they come in.
Yes.
Lynn, do you want to start with the legal analysis?
Yes, thank you, Mr. Chair. So I did the legal analysis for these separately because they are each a little unique, though 806 is the most unique. Let me screen share. I'm going to screen share my analysis and then I will screen share the sponsor's amendment that she just sent to us this morning. So this is LD 806, an act to clarify that municipal officers may accept a proposed unaccepted way for pedestrian, bicycle, and other non-motorized use. The title is fairly self-explanatory. Senator Carney introduced this bill and she talked a lot about the increased demand for trails for running, walking, and biking, and that the recreational easement rights under current law, when it comes to proposed unaccepted ways, is a bit unclear. There were several proponents of this bill. The town manager from the town of Cape Elizabeth, Maine Association of Planners, an attorney representing interested parties, and also they discussed the demand and the interest in outdoor spaces, the lack of clarity in the law, and an example is ongoing litigation in Cape Elizabeth. There were no opponents. Neither for nor against, excuse me, was Maine Municipal Association and the Maine Roadways. They talked about how this is a complex, nebulous issue with a mixture of public and private rights, and that is going to be the theme of all of our discussion on roads today. There was mention of the slippery slope and the encroachment on the private rights of individuals, discussion on ensuring that this is restricted to true paper streets. And I will use the phrase paper streets interchangeably with the phrase proposed unaccepted. And there was quite a few people who submitted written testimony. So the current law talks about proposed unaccepted ways. It's not defined in statute, but it's commonly understood to mean the proposed street laid out in a recorded subdivision plan. And again, they're often called paper streets because they exist on the paper. In 1987, the legislature enacted the Paper Streets Act, and the last section talks about the purpose of the act in 1987, which was enhancing the merits of title to land by eliminating the possibility of ancient claims to proposed unaccepted, unconstructed ways. So at that time, it was to provide clarity on and to remove these ancient claims that may be out there. I've laid out what the current law says about proposed unaccepted streets. The public gets a right of incipient dedication for a public use, when a paper street is created, and that is good for 20 years. The municipality may apply to extend the time period that they can accept these paper streets for up to an additional 40 years in 20-year increments. A municipality does have the ability to vacate their interest in whole or in part if the way hasn't been accepted. And the municipality may accept the way as a town way or a public easement, utility easement, or recreational easement. And the theme of easements being unclear is also going to be another theme that runs throughout our discussion on roads. I think a utility easement is defined in statute. If not, it's fairly commonly understood. What is a public easement versus a recreational easement is a very good question. I did not find a definition of recreational easement, and there are a few definitions of public easement. The private rights in these paper streets is a right-of-way on the plan. And the right-of-way, the private right-of-way terminates if the road isn't constructed or utilized, but the property owner of the land that abuts the paper road does get ownership interest into the road if it's not accepted. And I just threw in the definition of what a private way is, which is from a different title than the one we're looking at. And it means a privately owned and maintained. So the terminology is important for the bills that we're going to be discussing. The information that, or the testimony that I think raised some issues about the need for clarification if you're going to allow a municipality to create this type of easement on a paper street, that there should be further clarification about all the public and private rights and responsibilities if that were to occur. And I'm gonna stop sharing this and share the sponsor's amendment. And when I talk about public and private rights, you're talking about the liability of if something happens on the street, maintenance and the like. Let me screen share. So the sponsor did provide an amendment this morning. Do you see a piece of paper that says section 3036, pedestrian and bicycle paths? Okay, so as you can see, the sponsor added a provision that says municipal officers can accept these proposed unaccepted ways for pedestrian, bicycle, and other non-motorized uses pursuant to a process and standards established by the municipality. So this is addressing in a very broad way, but addressing the issue that municipalities need to provide some form of process so that the landowners and others have the right and understanding and ability to have some due process rights. And due process rights is another theme that we're going to talk about a bit this morning when it comes to roads. So that's the sponsor's amendment, and that's the end of my analysis. I will take this down and answer questions or defer to others.
Well, thank you, Lynn. Representative Copeland, you have your hand up.
Thank you, Mr. Chair. I do. I'm going to have to recuse myself from this one. I worked on the litigation in my professional career. And so my question to Lynn is, should I recuse from just that one? We're hearing 3 bills on similar topics.
And you were involved in litigation on
the Cape Elizabeth matter. Yes, I'm a legal assistant, and I worked on that for some time, and I have inside knowledge.
I think that this is pretty unique in that it would only be 806. That would be my sense. I mean, the other 2 are a bit different, and there isn't litigation in them that you're involved in.
Thank you.
Okay, any other questions? Representative Reisman. Representative Reisman, you're on mute. Yeah, there we go.
All right. Question for Lynn. So in the case of subdivision history, we're talking about roads where a subdivision was originally proposed and accepted by the town. Yep. No,
Not accepted.
the subdivision was not accepted.
This is talking about situations where there was a proposed way, and in those situations where the town has not accepted the way to be a street, this is giving the town specific, clear ability to create a certain type of easement. The statute currently allows municipalities, when it's a proposed street, proposed way, they can accept it as a road, they can create a utility easement over it, they can create a public easement over it, or they can create a recreational easement. And because recreational and public aren't defined, this is kind of clarifying that they have the right to create a bicycle, pedestrian, and other non-motorized use.
Well, you partially answered what my question was, but let me try this again.
Okay.
So here's an example. Let's say I own 100 acres and I want to subdivide it. So I go to the town and say, I'm going to put together a subdivision, right? I go to the town with a site plan review and it shows the layout of all the lots and it has these proposed paper roads in there. But nothing ever happens with it. So how does the town have a right to create an easement over there if they don't haven't approved the subdivision?
They have to approve the subdivision.
Okay, so now we're assuming that subdivision was approved but was abandoned.
Or never built.
Well, that's
right. Yeah.
Pretty much the same thing. Yeah. So generally, when a town has to look at a site plan review and it has a paper road going in there, it doesn't become a town road until that road meets the standard for as a town road. Well, meanwhile, you have an easement going through there, but it's not owned by the town, it's a private easement.
Mm-hmm.
So now we have a private easement that we're saying the town can put a bicycle route through there without permission of the landowner, of the subdivision owner.
Is that a question? Was that a question?
That's a question, yeah. Yes.
Do you understand the question?
Yes. So when a landowner proposes a subdivision and a paper street, the municipality has rights for 20 years. They can then, so that during that 20-year period, they can accept the road. They can create a utility easement, a public easement, or a recreational easement during that 20-year period. Or they can do nothing, or they can actively vacate their interest. So they have options, the town does, for those 20 years, regardless of whether houses are built or whatever else.
Okay, Representative Toole, and then Ms. Manter.
Thank you, Madam Chair, Mr. Chairman. I guess my question, if we have Kate Knox with us, I know I spoke with her late last week about this, and maybe she can add more clarity to the whole situation. If we could have her come in and weigh in and speak to this issue.
Okay, we'll call on Ms. Knox in just a minute. Ms. Manter, did you have a question?
I think I can answer the question that's been posed, or at least provide some clarity on it.
Well, why don't you try?
I want to, excuse me?
I said, why don't you attempt to do that? That would be great.
Okay. When a subdivision is proposed, the town can accept the subdivision, but not necessarily accept the roads within the subdivision as town ways. So the subdivision may be partially built, but not completely built. Some of the roads may be built up and used. Some of the other roads may never be built. The private rights in those ways, if there have been lots sold with relation to that subdivision plan and those lots require that road for access, then that road remains as a private easement for those lots that have been sold with relation to the plan. If there are not any lots that are sold with relation to that paper street and the paper street is never built, then it remains what we call a paper street. It's a road that just, it's there, but only on paper. It's never been built, it's never been used, and there isn't any lot that depends on it. I know of one situation in Bridgeton where this has happened, where there was a subdivision that was laid out. A few lots were sold with relation to that subdivision plan, and then the rest just sat there and nothing was done with them. And recently someone bought the entire remaining piece of the subdivision with a road with 6 house lots laid out on that road, but that road had never really been built. It had been roughed out and that was it. And he built the entire thing and got the person who had proposed the subdivision to sign off on it. So the entire subdivision is no more and that paper street is just going to be extinguished. But there was another road within that subdivision plan that is being used, and that there are lots laid out with relation to that road, and that will remain a private road. Does that answer the question?
Well, hopefully it provides some clarification. Ms. Knox, welcome. I would also indicate before you get started, Senator Claxton has joined us. Senator Claxton, did you want to introduce yourself?
Good morning. I'm Ned Claxton. I represent Senate District 20, which consists of Auburn, Minot, Mechanic Falls, Poland, and New Gloucester.
Great. So, Ms. Knox, can you provide some additional clarity or answer some questions?
I can certainly provide some information. Thank you, Senator, members of the committee. I know you have a busy day today, so appreciate the opportunity to speak briefly. The concern that my clients have, which are 4 landowners in Cape Elizabeth about this bill, is really a little bit narrower than what you've been discussing, although what I think you're touching on is the very deep complexity of the rights related to these paper streets. It is a web of ownership interest that sort of vest and expire and change. And obviously you have a lot of experts here, Rebecca and Roberta, who can talk about that. Our concern basically is that this particular bill would put a thumb on the scale for a very specific matter that is highly litigated in Cape Elizabeth right now around a very specific paper street. And that has to do with a subdivision that was created in 1911. There was an incipient dedication of a paper street. My client's houses abut that street. Also, one of the owners technically owns the paper street now. It has been an 8-year-long, very acrimonious, contentious, deeply emotional conflict in the town of Cape Elizabeth that you may have read in the paper. It was in the paper last year that the law court essentially opined and said they said rights have not expired. To be fair, they said that town's rights have not expired, but we can opine on whether the town can use this as a recreational pedestrian bicycle path because the town has not taken any steps to affirmatively accept the street. So that is the exact issue before you and is the exact issue we expect to go back to the law court once the town makes an affirmative move to accept the street as a bicycle path. If this committee decides to pass this piece of legislation, what it essentially says to the law court is, we believe that public easement includes bike paths, which is the exact issue we are trying to litigate in front of the law court. The complexity of these streets, the individual factors that go into determining whether a particular paper street, whether rights have expired, whether it should be a street, whether it should be a bike path, they're very fact intensive. They're very individual. That's why they go to the courts. This concept of incipient dedication is a court developed doctrine to help them manage how paper streets, how they sort of litigate these paper streets. And what we would argue to you very strenuously is, please do not get involved in this very local, very contentious issue. This is something the town of Cape Elizabeth needs to work with the property owners on. It needs to work with the abutters, and asking the legislature to weigh in on this is really an end run around a process that we're in the middle of, and will significantly disadvantage the abutting property owners in ongoing litigation. This is an 8-year-long battle. I'm happy to answer any questions about it, but in the interest of time, I'm not going to sort of delve into that piece of it. Kara Leopold, who is one of the property owners, is here if you want to hear from her. And I would just quickly say on the amendment, I appreciate Senator Carney sending it to us, and we've taken a look at it. It doesn't substantively change sort of the dilemma that we think it puts us in, which is that if you say in statute, it's okay to use this as a bike path, it circumvents this factual analysis that the court does. And that the amendment basically says that the town can do it based on a process that the town comes up with itself. So it doesn't give any, it doesn't acknowledge or help the landowners in the process that we're going through. So I guess I'll stop there. I'm happy to answer any questions.
Okay.
And again, appreciate that time.
Yep. Any questions for Ms. Knox? I see Representative Toole, I will get to you in a moment, but the sponsor, I want to recognize Senator Ann Carney. Welcome for joining us today. And why don't you go ahead and give us your reaction to the analysis that you have heard so far today?
Yeah, and I actually would really appreciate the opportunity to introduce myself as well as the bill.
Sure. Oh, absolutely.
Thank you very much. So I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I appreciate the feedback that you've received from Ms. Knox. She raises a big question. Well, let me take a step back. First of all, this is actually a really simple bill. We've got 2 different sections of statute that deal with paper streets. One of them says the paper streets can be used for recreational easements, and the other one is silent. They follow each other in the statutes, and this bill simply asks the legislature to clarify that a paper street could be accepted for non-motorized as opposed to motorized use. It's the only change it makes. It exists within a framework that has a lot of process about when and how paper streets are accepted. The addition that I added, the amendment to the bill, provides yet another layer of process by requiring the municipal officers to create criteria and a process for accepting paper streets. And what that municipal process does is it brings into the statute the particular preferences and needs and uses that would occur in the municipality that is contemplating whether or not to accept a paper street. And so it provides an opportunity for municipal input in creating the process and the criteria. And then when that process and criteria is applied to any particular paper street, there is yet another round of weigh-in by affected property owners and also by members of the public, which I think we have to realize and recognize that the public has incipient rights in these paper streets. And I feel as though they're being kind of left out of this conversation. Ms. Knox, I appreciate her feedback. I think my concern is that, she's talking a lot about ongoing litigation and the courts, having to weigh in on this, but we, and I'm talking to the committee members, We are the legislature. Our role in the three branches of government is to create legislation that establishes state policy. And here we've created legislation that has a lack of clarity. One part of the statute mentions recreational easements, the other doesn't. It's our job to set that policy, not to leave it to individual landowners to litigate before the court system. That's our role, and I'm asking the committee to take that important step of clarifying the law, ending the litigation, and most importantly, for sticking up for the rights of the public in these incipient streets. It's a really important aspect of Maine's tourist economy. It's an important aspect of communities' use of the incipient public rights. And it's tied to, as I think I mentioned when I introduced the bill, it's tied to our desire to focus more on passive recreation and non-motorized use as we address climate issues. And I think it's a really important public policy for us to weigh in on. Thank you for hearing me out.
Absolutely. And our Representative Toole, do you have any questions for Senator Carney or for anyone else?
Thank you, Mr. Chairman. My question more or less was for Ms. Knox. And I know your concern is this is very narrow and targeted towards the Cape Elizabeth situation, which from everything going on sounds that way. But my question is do you have concerns that there are other situations around the state, either in a similar situation or could potentially or have been in recent years? Have you done any research on that?
Yeah, thank you, Representative Toole. That's a great point. I have not done any research on that. But I think that there are certainly these types of situations all over the state. And I think you had some testimony to that degree, that many people don't even realize these paper streets are abutting their property or running through their property. And you heard Ms. Caswell talk about sort of how they, I don't even want to say come into being, because they're in this sort of limbo state of, are they a street or are they not a street based on where they are in this process. And so I think there are two concerns. And I didn't mean to sort of be overly narrow. The point I'm here to make to you is about this very specific Cape Elizabeth situation that's ongoing. But I think this has been one of the more public disputes over a paper street. It's important to note paper streets are not unusual. They are all over the place. And the question is whether people know about them, whether they become a subject of dispute. We unfortunately are in a situation where this is a huge topic of public dispute. And I'm sure Ms. Manter or Ms. Graham can sort of, they may have better numbers than I do, but my understanding is that they are everywhere.
Okay, thank you. Senator Carney, you want to respond?
I mean, I think that's right. I think that Ms. Knox is here on behalf of a small group of landowners, but there are paper streets all over the state. And that's why I think that just emphasizes my point, which is that it's really important for us as the legislature to set statewide policy on this important issue of public access and creating opportunities for non-motorized use in our state.
Okay, thank you. Excuse me. Any other questions by members of the committee? Representative Matlack?
Thank you. I'd like to hear from Ms. Graham from MMA about this issue and how it impacts municipalities and what she's seeing perhaps on both sides of the issues with regard to these paper streets. I did talk to my local assessor, and one of my local assessors, and what he said was, well, there's this one paper street and the select board would really probably like to have that as a pedestrian walkway. Another one, they don't want to touch at all because it's so complicated and convoluted and litigious that they don't want to go there. So I'm wondering if Ms. Graham has some input on how municipalities are dealing with this and whether this legislation will clarify or obfuscate.
Okay, thank you. Ms. Graham, go right ahead.
Thank you, Representative Matlack. That is a hugely philosophical question, I think, from MMA's point of view, as both your assessor and your hearing today. Each one of these is really fact intensive. They are local in their construction and they are local in all of their problems and involve multiple individuals and have competing interests. So once that is accepted, there's a mutual ownership in essence for these paper streets for a defined period of time. And that is why the court tends to get involved in that. And all of the issues that we had brought up in our testimony were specific to, we don't actually know how one would construct something to deal with this in a way that would be uniform, but we do know that there are these concurring interests, there's concurring liability issues to assume as well and to go over. So we're hearing a lot of concern from our Legislative Policy Committee about that because they have in some even town or large cities, huge amounts of paper streets, and in smaller communities, they have paper streets that may never ever be built, but also might in future create landlocked properties should that municipal interest be removed. So it's an extremely complex issue, and that's kind of where we're at. Like, there probably needs to be a more significant process that would be associated around that, and some intense understanding of those concurring interests in a way that both the discontinued roads and the abandoned roads have a completely other set of issues around them as well. Very different than the paper streets piece, because from the beginning, there's an expectation that the municipality will maintain this public easement from the start and from the submission, both by the initial subdivision submitter and the community who is part of the planning board process, basically.
Okay, Representative Matlack, did you have any follow-up questions?
No, not really. I was wondering if perhaps this touched on what Senator Claxton his bill was dealing with, or whether this is something aside from that also.
Yeah, Senator Claxton, I don't know if you're able to seek any connections between your bill and this bill.
No, we tried to make our bill, Representative Toole's bill and mine, as focused as possible, and does not touch on anything related to paper streets.
Okay. Okay, Senator Carney, you still have your hand up?
I actually thank you for recognizing me. I took
Absolutely.
it down and put it back up because I also did want to say that I appreciate a lot what MMA has said. And when I had extensive meetings with one of the landowners on one of the paper streets at dispute, and with a group of other landowners related to another paper street within my community. And again, I actually don't see this as an intensely local issue, but they did give really important feedback that there needs to be, if you're considering using a paper street, accepting it for recreational purposes, there does need to be process, and there does need to be an opportunity for all members of the community, including nearby and abutting property owners, to weigh in. And that is why I proposed the conditioning acceptance for recreational purposes on the specific municipality taking into concern all of those local issues in setting up a process and criteria, and then taking into those all of those local issues when undergoing that process with respect to any particular paper street. So I just wanted to include that, and also just briefly to address the liability issues. I don't think that those are relevant because the municipality would be immune under the Maine Tort Claims Act, and there also is immunity for landowners under, I think it's Title 14, Section 156. I'm not 100% sure, but that talks about no liability for unimproved land that's accessed by the public. Thank you for hearing me out on those two issues.
Absolutely. I just want to say, as an attorney, I concur in the comments where everybody says it's complicated and complex. and it ends up in court. And unfortunately, it's where a lot of these road issues go. It's difficult to decide on a case-by-case basis, but that's where we are kind of right now. Is Mr. Doak, did you want to add anything to our conversation?
Thank you, Senator. I've kind of stayed out of this issue. Most of our members are not involved in the paper streets, and I don't want to complicate your world anymore by commenting. So thank you.
Okay. Thank you. Any other comments or questions by members of the committee? Do committee members want to entertain any motions? Representative Greenwood, you have your hand up.
I'll make a motion of ought not to pass.
Okay, is there a second?
Second.
Okay, it's moved and seconded. Representative Reisman? You are still mute.
I want to make sure that we know which bill we're actually voting on. Because this one doesn't sound like Senator Claxton's bill. It sounds like.
It's not.
Okay, so what bill number are we?
Then you want to clarify what bill number we're voting on?
Yes, thank you, Mr. Chair. We're voting on LD 806, which is Representative Carney's bill, and it's an act to clarify that municipal officers may accept a proposed unaccepted way for pedestrian, bicycle, and non-motorized use.
Thank you.
Just to clarify, that was my motion.
Okay, and I'm assuming, and then Representative Toole is nodding in agreement. Representative Matlack? Oh, I'm sorry.
Thank you, Mr. Chair. Okay, my apologies. Thank you, Mr. Chair. I'm not an attorney. I'm a legislator, and I do not want to wade into a legal matter. And that's my concern here, is that we are wading into a legal matter with this bill. So I'd prefer that the folks at the municipal level deal with it in their manner, and that they come back to us with legislation after this legal matter has run its course. But for right now, I don't want us to step on one side or the other of this issue. And I prefer to stay out of it for right now.
Okay. Any other questions or comments? Okay, so we will ask Cheryl to call the roll.
LD 806 ought not to pass. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton.
Yes.
Senator Ned Claxton, yes. Representative Ann Matlack.
Oh, thank you for the promotion. Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
Yes.
Representative Randall Greenwood, yes. Representative Sean Paulus. Oh yeah, absent, sorry. Representative Francis Head.
Yes.
Representative Francis Head, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Lynn Copeland.
Recuse.
Representative Lynn Copeland abstains. Just a reminder, from now on, you only have the next business day whenever you miss a vote to turn your vote in. Thank you.
Okay, I just want to, Senator Carney, before you go, first of all, I think that Representative Matlack's comments are pretty much where we are. It's not a reflection on anybody that's involved in this case. It's really just trying to step outside of a ongoing court case. But maybe we can revisit this issue at some point, but we really very much appreciate the work you're putting into all these issues. So thank you. And Representative Bryant, did you have a comment?
I just want to respond to Ms. McGowan's statement. Is that next day for voting? Is that noon time or is that 5 o'clock?
Noon o'clock, 12 o'clock, yes.
So Senator Carney, thank you very much. We look forward to working with you in the future.
Thank you all so much. Enjoy the rest of your workday.
Thank you. Okay, the next item is, I believe, 596, the long-awaited roads bill. And Senator Claxton is with us, as is Representative Toole. Lynn, do you want to present your analysis?
Thank you, Mr. Chair. So this bill, LD 596, was considered by the 129th legislature in the first session. The 129th established a subcommittee of which Senator Claxton was the chair. Representative Toole, Head, Reisman, and Bryant were all members of the committee last session. I don't remember if any of them were on the subcommittee. I think some of them were. The subcommittee came back with a report to the second regular session based on their work. It was a unanimous report from the subcommittee. Roberta Manter, Rebecca Graham, and Tom Doak were all very involved in the subcommittee. The committee voted the bill ought to pass as amended. And as happened in the 129th, it was not taken up before the committee adjourned. The bill you have before you, I believe I checked it, and it is identical, if not substantially identical, to the bill that the SLG committee worked on and reported out last session. The issue of abandoned and discontinued roads is complex. I'm going to go out on a limb here and say it might be more complex than paper streets, but it has many of the very same issues. The 129th subcommittee worked to focus on specific issues that they could get unanimous consent on. And if any of you have looked at the report back from that, it listed, I believe, 14 issues that the committee looked at and whittled down to just a few. And that was what was in the original bill from the 129th and in this bill. So what the subcommittee focused on was due process for those individuals affected if a road is abandoned, clarifying the scope of the public easement retained in an abandoned road, and that is clarifying the scope going forward. It would not impact existing public easements on roads that had been abandoned before the effective date of the statute. This bill has an effective date of October 1st of 2021. So it doesn't affect the status of prior roads, previously abandoned roads. It does not affect the easement rights on previously abandoned or discontinued roads. The bill was drafted to make the process optional for municipalities. However, there was strong testimony in the 129th and in this session from MMA about whether or not this truly is an optional process. In the 129th, this bill did get tagged by OFPR as a potential state mandate. It was drafted to avoid the state mandate tag, but it was still identified by OFPR as a potential state mandate. Many proponents of this bill, and they were proponents because they were in favor of creating this due process for property owners and clarifying the scope of the public easement. And again, it doesn't require the municipality to maintain the road. I believe I've already gone through most of MMA's comments, as well as the Maine County Commissioners commented as well in opposition to this bill. So roads has a long history. Every session there are bills. Since the 125th, there have been 3 subcommittees. The 125th had a stakeholder group run by the Department of Conservation. The 127th had a subcommittee. And of course, the 129th had a subcommittee. And you can see, I'm not going to go through this, bills every session, some are passed, some aren't passed. I would say, looking back, I would say that slowly but surely, the law of abandoned and discontinued roads has evolved, but not all the issues are addressed. I probably should step back and say, what's the difference between an abandoned and a discontinued road? Abandonment under current law occurs after 30 years of no maintenance by a municipality. Discontinuation of a road is an active process where a municipality provides notice, due process, and they actively decide not to continue maintaining a road. There is also this concept of common law abandonment, which I think was created in the 1800s by the courts, but don't quote me on that. And that basically says that if there was no use of a road for more than 20 years, it's presumed to be abandoned. There is some dispute, there is some conflict in the courts between the common law abandonment and the statutory abandonment. But that is more weeds than you want to get into. I think there was a question asked about what is the current statute on abandonment. The current statute says it's presumed that a road is abandoned after 30 years of no maintenance. And a municipality can act on that presumption by deciding that the road is discontinued. And they also, in subsection 2, the determination of the municipal officers regarding the status of the way or the public easement is binding on everyone. And there is a filing requirement. Discontinuation, as I said, there's a lot of others. Discontinuation, as I said, has this notice process, filing with the courts, the Registry of Deeds. And the change that was proposed in the 129th and is in this bill is to add into abandonment this process. I'm just going to fly through this to see if I had anything else to show you. So the purpose was to create this due process. The due process goes to not only those owners who have property that abuts a road, the notice also goes to what are called affected property owners. So someone who property does not butt the road, but they need to go down that road to get to their house. It also provides notice to neighboring municipalities and so that if the road goes from town A into town B, the municipality town B knows that what town A is up to. I could go on with more details, but I'm going to stop because, as I said, this is weeds, and I'm going to take questions or allow the chairs to identify someone else.
Okay, anybody, members of the committee want to ask any questions?
Oh, sorry, Senator, I forgot one thing. The other important thing is the scope of an easement. So this bill, to prevent future problems, this bill identifies what the scope of the public easement is in an abandoned road moving forward. The scope of the public easement under this bill was pulled from the public easement a municipality can impose under the eminent domain powers. So this is not a recreational easement, which is undefined. This is not a utility easement. This is a specific easement that is limited to the same scope as the eminent domain public easement. And that was a conscious decision of the subcommittee and the committee last session to use that same language. Now I'm done. Thank you, Mr. Chair.
Okay, thank you. Senator Claxton, did you want to comment on that analysis?
Just briefly, Mr. Chair, thank you. The only contention I have with Lynn's review of the history is it doesn't start from the King's Highway. That's when we really started with road issues. And what we've been trying to do is nibble at the edges of these things, trying to resolve things as specifically as we could. And it quickly became apparent to me last session that there wasn't, we weren't going to solve roads or abandon roads, but we could identify a few things we could work on. And the committee, which included Representative Head, brought her real estate experience, and Representative Toole brought his brain and his experience with SLG over time. And we really tried to whittle this thing down to a manageable, negotiable whole, and we're aided by the expertise of Ms. Mander and Mr. Doak. So I understand the issue, and we struggled with it about the mandate. If the work of getting roads abandoned, which was intended in the early 70s, had been completed, we wouldn't be having this conversation. But there are roads that should have been abandoned, officially abandoned in the past, but then periodically somebody would do something to them and make their status unclear. We're just trying to make this, we're trying to create fewer problems in the future with this bill is basically what it does. And it may well cost a few municipalities, the rare ones who haven't completed their abandonment work from now 40 years ago or 50, some additional work. And I understand that, but I also think it's worth a fiscal note, and I'd be more than glad to work for a 2/3 vote to get it through. Thank you.
Okay, thank you. Representative Head or Representative Toole, did you wish to make any comments about the bill? Representative Toole, I see your hand up.
Thank you, Mr. Chair. And I have to say that were it not for Senator Claxton and his willingness to compromise and come out with a manageable solution, we probably would not have got it through last year or even through the subcommittee. These issues keep coming back. They're not black and white. We're going to be dealing with another one today that wanders back into this whole thing again. And it's not nearly so clear cut, but I think Senator Claxton and Lynn, all of the stakeholders really worked hard to narrow the scope and focus on a few things like due process. We may not ever solve the road issue per se, but if people can have confidence in the process that is being followed for dealing with that, then I think we've done as good a job as we can possibly do, because so many of these are local issues and have their own local dynamics. And not to confuse this with the previous bill, but we can guarantee a process. We can't necessarily go wandering into local issues. So I definitely support this and think we should move forward with it, realizing that there's so many other issues that we could deal with on abandoned or discontinued roads and will deal with for years to come.
Okay, Senator Claxton, you have your hand up again.
Yes, I'm sorry. I have to pop over to HHS to be the token senator, and I'll be back as quickly as I can.
Thank you. Representative Bryant. Representative Bryant, do you have your hand up?
No, thank you. I was going to make a motion, but I would wait if Senator Claxton one needs to come back.
Oh, I don't expect him back for a little while. So I think we can entertain a motion.
Move on to pass. This is not an amended one. This is the same as we had. Is that correct? So I move on to pass.
Okay.
L 596.
I'll second that.
Okay, do we have to do auto pass as amended because of fiscal note, or are we all set, Lynn?
If you just agree that if there's a fiscal note, I can change your vote to ought to pass as amended, we're good to go.
Okay,
Thank you, Senator. That works for me.
okay.
And me
it's
as well.
moved- Okay, thank you. It's been moved and seconded. Cheryl, can you call the roll?
Yes, I will. LD 596 ought to pass. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Hall.
Randall Greenwood, yes.
Oh, geez, Ronnie, he's on my other committee. I can't
I know.
even read. Representative Randall Greenwood, yes. Representative Sean Paulus, absent. Representative Francis Head.
You have to unmute. There we go.
There it is.
Yes.
Representative Francis Head, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. 10 yes, 3 absent.
Okay. And thank you. Also, thank you, Ms. Manter, and thank you, Mr. Doak and Ms. Graham for being here as well. So we have one more road-related item, and that is LD 1513. Is Representative Newman?
No.
Okay. He got a link, didn't he? Or
Yeah, I actually sent him another one this morning,
okay. Okay.
just to make sure.
Yeah. Yeah. So Lynn, do you want to go forward with your announcement? Senator Claxton, you are back. So you're on mute.
Did
So-
we vote on LD 596? If so, I'd like to register my vote.
Yes. Yes. Go right ahead.
And the motion was ought to pass as amended, as I understand it.
Yes.
Then I'd vote yes.
Okay.
Senator Ned Claxton, yes, on ought to pass, LD 596.
Okay. And what's the
Thank
vote?
you very much.
What's
Now
the
it's 11-2. Well, 2 absent.
two absent? Right.
Yes.
Okay. Thank you, Senator Claxton.
Thank you.
Lynn, do you want to go ahead with your analysis on this, on LD 1513?
Yes, thank you, Mr. Chair. So this bill is an act to require the maintenance of a discontinued public road that provides the sole access to one or more residences. And I'm going to share my screen. This was a bill from Representative Newman, and he discussed, as did the proponents, Maine Roadways, Maine Association of Realtors, and several individuals who provided written testimony, that if a municipality retains a public easement in a road, that they should at least be required to provide some amount of access. The bill specifically states that it has to provide, let's see, the municipality is not required to keep the road or way safe and convenient for travelers. The requirement is that it's passable to access the residences on the road. MMA was opposed to this for 2 reasons. One was it was an unfunded mandate, and also the involvement of the county government in municipal affairs. And that is one of the matters that I highlighted for the committee to consider. This bill requires in the first section that the municipality maintain the road passable to access the residents on the road or way as determined by the county commissioners. And I would just highlight that that phrase, as determined by the county commissioners, may be a bit too vague. You may want to think, if you're going to move forward with this bill, MMA doesn't consider it appropriate. And I would advocate at least that it be a little clearer if the county commissioners are going to have some input. Either is it a specific county commissioner, are you talking about the road commissioner, or is there going to be a process for the input from the county? There was no fiscal impact. I have already gone through the prior sessions discussion on these types of bills, and this has come up in the past. So I won't continue, I won't go through that again. Let me just check. That was the end of my analysis. So thank you, Mr. Chair. Any
Okay.
questions?
Any questions, Representative Tool?
Thank you, Mr. Chairman. So, I mean, a couple of questions. I know in the 128th, there was a bill to deal with basically setting up a due process for discontinued roads. I wasn't on the committee that year, but I'm told there was. We passed it into law. Did you, Lynn, did you have any more insight on that, or what the discussion around that was, or anything of that nature?
I will share what I learned from review, and I'm sure there are others here that have that history. But in the prior session, the discontinuance statute was improved to include a robust due process that included notice, public hearings, abilities for those affected to participate prior to a road being discontinued. And that process also could include the existence of a public easement or the type of public easement. So that in that session, that was the outcome of the work of that subcommittee, was to make that process more robust.
And with that, were there any other issues? I hate to even ask, were there any other issues to do with discontinued roads that the subcommittee identified that could be addressed in future legislation? I mean, I think there's a value of possibly carrying this over and looking at the issue in a broader sense, because there are so many moving parts to the whole thing. But I'm wondering if you have any historical background on that.
Thank you, Representative Toole. The committee did identify that the maintenance of a public easement on a discontinued way as an issue. And I think you've heard quite a bit of testimony on the bills that have come this session, that the public easement that's retained on a discontinued road is a source of contention and headaches for all sides of the issue. It was not addressed in that session. It was, I will say, discussed in the subcommittee in the 129th that Senator Claxton shepherded, and it was not an issue that the subcommittee felt it could adequately address. But you're correct, that was an outstanding issue.
And I would say with that, if folks were interested in revisiting that aspect of it, I mean, I wouldn't have a problem carrying this over, because there are so many moving parts. I'm not saying the outcome ought to be, but there's a lot of, if we were to pass this without doing all of the homework, we could potentially get into a minefield of issues and unintended consequences, as we could have with the previous bill, and even with 806, which, simple as that sounded, really got away from us pretty quick. So
Okay.
I would be open to carrying it over if folks are interested.
Okay. Lynn, you had some comments?
I did, and I don't know if I was clear enough that if this passed and municipalities were required to provide some level of maintenance or keeping roads plowed and such, it would create a mandate on the municipalities. So there would be a fiscal note. And that is one of the, issues that has prevented resolution in the past.
Okay. Any question, Representative Greenwood?
Yeah, thank you, Mr. Chair. Just as a point of clarification, the municipalities have the option to not retain a public interest and therefore would not be required to provide any cost. So this is really only affecting properties that municipalities wish to retain public interest. And I guess I don't really see where this would be a mandate, because the municipality can make it go away with, if they don't want the property, they simply return it back to the abutters and not retain it for public access. Would that be a fair assumption, Lynn?
Theoretically, yes. I think that the issue is complicated because over the years, the public easements were at certain times automatically retained, other times not automatically retained. So in reality, it's complicated for a municipality to know whether or not there is a true public easement on a specific road. But theoretically, yes, you're right. A municipality could say, yes, we want to retain a public easement on road X, and therefore we have an obligation. Or they could say, no, we're going to get rid of a public easement on road Y so that we don't have that obligation. But again, theoretically, it sounds a lot easier than practically. And I think that's what Representative Toole was, and others have pointed out.
Okay.
Can I follow up?
Sure, go right ahead.
Yeah. I mean, I guess we have, I'll call experts in the field, with Ms. Manter and Mr. Doak. And I guess I'd like to have them weigh in on their thoughts on that. Because again, this is only an issue if the municipality wants to keep public easement on it. It doesn't affect property in which they return back to the abutters. Can they both weigh in on that?
Yeah, I was about to recognize Ms. Manter. Ms. Manter, go ahead if you wish to comment.
Yes, first of all, I want to thank Representative Toole. If you wanted to hold this over and work on it, I'd certainly understand that. And I would certainly prefer that to voting that it ought not to pass. There are some complicated issues here. We've put a lot of thought into trying to come up with wording for this bill. And I would argue that it's not a mandate because the town does have options. Thank you, Representative Greenwood, for pointing that out. And Representative Toole, you mentioned what the changes were in the discontinuance statute that were made a few years ago. One of the big changes was that towns were given the option of contacting, or actually they're mandated to contact the abutters who depend on that road for access, and allowing them the option, if they want to, of granting each other private easements in common. So that nobody would be landlocked, but the public easement could be given up. And that gets rid of one of the big issues with these roads, which is that although the town ceases maintenance, they keep a public right of access. And that right of access hasn't been limited in any way. It's sort of been an open door. So these are subject to four-wheel drives, ATVs, even log skidders skidding their logs right down the road. It's basically, if it's public use, anything goes. And that causes a lot of damage and a lot of problems for the people who depend on that road for access. So with that amendment that was put into section 3026A to allow the public easement to be given up and private easements in common to be put in instead, that is one of the options that this bill would open up. That when a road is abandoned and still has this public easement hanging over it, if the town doesn't want to have to put in any maintenance on that road, they have the option of negotiating with the landowners to try to make it a private easement. The town also has another option, which is reduce the taxes on those residential properties to just what they would tax for raw land with no buildings on it. And that gets them out of the obligation to provide maintenance. And again, that would provide some relief for these property owners, because then they'd be using just the money that would ordinarily go for taxes and be used somewhere else in town can go back into the road, so that it helps them a little bit with the cost of maintenance. My preference probably would be to go for the private easement in common if that can be worked out. But
Okay.
sometimes you have one property owner who won't agree to that.
Okay, thank you, Ms. Manter. Mr. Doak?
Thank you, Senator. The principal reason for a public easement was to avoid landlocking. I mean, that's the reason, that's the principal reason those existed in the first place and were automatic. And so because of the constitutional issues, the town can't simply give the road to just a few people. So the public easement was designed principally to allow everybody that had to use that road to use it. It has evolved into quite a problem for a lot of people who end up maintaining the public easement, and the public uses it, and essentially you have private landowners maintaining a public resource. So that's the real rub, and that's why it's been very difficult to deal with this issue of as Ms. Manter says, there are options. A municipality could get rid of the public easement, or they could work with the landowners. But when that doesn't work, you still have a situation of potentially landlocking. So there are issues around this that might have some resolution, but it's been a very, very difficult one. But it is a major issue for landowners, because they end up with, they own the land where the public easement is, they own the liability that comes with it. And then the maintenance responsibility, and the public uses it. And that's the real rub that you see. So it could be worth getting folks together and see if there's some progress that could be made. But this is one of the hard issues.
Okay. Representative Toole, you have your hand up again.
Yes, I thank you, and I thank both Ms. Manter and Mr. Doak for the comments there. I certainly think if folks have an interest in moving forward with this, I think it would be prudent to carry it over. And I say that because part of the issue with the mandate centers around going forward. If this were to be going forward, there probably a mandate could possibly be avoided. But if going back, you already have situations that are in place that were based on certain circumstances. Now towns are stuck in a fix of having to go back to square one with a law that they already were dealing with. I wondered if, Lynn, is that where you see the mandate coming in with existing situations versus going forward?
Yes, I think going forward, you're right. A town would have knowledge and could decide. But yes, the status of and the existing and for the reasons that Mr. Doak outlined, what are you going to do if it's landlocked property? So,
Okay, Representative Copeland.
Thank you, Mr. Chair. I think there are a lot of issues with this. There's so many things to consider. I agree with Representative Toole that it should be, put off until next time. But I think some things that we need to think about in the interim. Of course, landlocked people have to have access to their property, and like the Manters, and they shouldn't have to maintain a road that truckers are using, loggers, because that's just not fair in any way. But there's also issues about, the municipality. If they have an option to go with the, without having that mandate, maybe they're missing opportunities for public access that is reasonable. So what about having public access restricted. So have it restricted to foot traffic instead of logging trucks. So it doesn't affect that the landowner has to do, and it maintains their access and their property and all that, and just allows for foot traffic through, where that wouldn't destroy the face of the earth in that area. So I'm wondering if that's something that could be considered.
Lynn, do you want to comment on that, or?
Thank you, Mr. Chair. I think that Representative Copeland has identified ideas that have been raised in the past, and there are a lot of good ideas. It's difficult finding the right ones, but yes, her ideas have been discussed, and I'm not sure I want to open the discussion on it specifically unless the committee is interested in amending this bill in some way in response to Representative Copeland's ideas.
Okay, fair enough. Ms. Graham, you have your hand up.
Thank you, Senator Baldacci. I just wanted to add to the conversation to say that public easements are already restricted to the types of traffic that can travel over them, and damage is already illegal to a public easement on a discontinued road. Those were also pieces of legislation that were passed out in very recent years as part of a system to try to address some of those. And we had previously also identified the need rather than for a local option, because oftentimes municipalities don't have a choice in keeping these rights of way because they either extend to water bodies, and the state has established a desire to retain those public easements, but also because of the same reasons that you just heard, that getting a private roadway and a road group together is a problem. If a single individual on that road does not want to give up that easement, then the town often feels like they have no choice but to retain that, even though the rest of the abutters to that might want to continue it. So it's often a compromise situation. It's not a desired situation. And municipalities are allowed to do that compromise situation because they aren't encumbering the property taxpayers, and they are trying to stay out of a neighborhood dispute. And so many of these particular issues are really local in focus and personality in focus as well on those areas. So that's why there has been such large flexibility around those issues in the past.
Okay, Ms. Manter, if you have a couple of points that haven't been shared yet, that would be fine.
Yes, if I can remember what it was I wanted to comment on. There were a couple of things. One is that Ms. Graham says that public use on these ways is limited. I'd like to know where she sees that, because I don't see it in the law. What I do see is a court decision that says that the public has an unfettered right of access over these roads, and they are in fact used by log trucks, skidders, ATVs, etc. I do agree that there was some legislation passed to make it illegal to damage a public easement with a motor vehicle, and to give the abutters a right of action against someone who damages it. But so far, I haven't seen anybody that has succeeded in using either of those laws. We've tried in several cases, and it's problematic for a number of reasons. You have to catch the person who did the damage. You have to prove that they were the one who did the damage.
Okay, well, let's see if we can get beyond that issue. Representative Toole.
Thank you, Mr. Chair. So I know what we did in the 129th was we formed a subcommittee to meet over the interim or during the break. Not that I'm volunteering to do that again, but I think some of these issues, maybe we could have a conversation, see where it goes, and bring something back, bring back a solution next year, whether it's dealing with properties going forward or dealing with some of the other discontinuance related issues.
So Representative Toole, are you volunteering? Is that what you said? You are volunteering?
I said I wasn't necessarily.
Oh, I thought you said you were volunteering, and I was accepting that offer, but
the chairs have the power to appoint whomever, so.
Well,
Generally,
Representative Matlack, what's your thoughts? Because we've had these discussions about carryovers. So what is your thought about this bill? You want to table it and then put in the box of bills that we're going to consider to carry over?
I think I'd like to hear from Lynn, but this sounds like it's been debated and discussed, and there has been legislation on this, and I understand the concerns about the municipalities. Well, the property owners have the right to find the people that are responsible for the damage, but I know that they won't because of either the lack of police or sheriff or the local law enforcement to assist in that matter. So that's going to be an insoluble issue. So I'm not sure we're going to be able to solve this issue very easily. It's one of those very dense problems. If Representative Toole is interested in moving forward with this, that's one thing. But I'd like to hear Lynn about how the issue was dealt with 2 sessions ago, and whether there's any potential for resolving this issue over the next 6 months.
Lynn, go right ahead.
Thank you, Mr. and Madam Chair. It's complicated. I hate to keep saying that. I haven't mentioned, and Representative Toole, when he talked about getting together people with interests and ideas, Mr. Doak will know what I'm talking about. When last session, there was a group that, and I can't think of their names right now, but when you're talking about ATVs and snowmobiles, so many of these discontinued and or abandoned roads are now part of ATV trails. And there's the ATV task force, and Mr. Doak's going to correct me if I get that wrong, that looked at a lot of issues related to, and so we're talking inland fisheries and wildlife, perhaps another department. And the idea of the public easement and what does it entail was raised because from that perspective, you may have a lot of these discontinued or abandoned roads that now are ATV trails or snowmobile trails. So if there's going to be a discussion, I think it needs to be broader than municipalities, counties, state and local government, woodland owners. It's a broad group of people that have interest in resolving this issue. And I will say that over the years, those people have worked on this and have yet to come up with a solution. And I am always a big fan of solving problems. Many people have been stymied by this. I'm not saying not to look at it, but I think it would need to be a robust conversation to figure out how to solve it. And thus far, nobody has figured out that solution.
Okay, on that optimistic note, Representative Toole.
Thank you, Mr. Chair. So, and I appreciate Lynn's jogging our collective memories about the ATV IF&W task force. I wondered if Mr. Doak had any insight as to what in respect to this issue was addressed within that, because I know they are dealing with a bill, a lot of the recommendations from that. So I guess I would just want to hear from him on that.
Okay.
Thank you. I did serve on the ATV task force that appointed by the governor, and we were all hoping this committee would solve that problem for everybody on the task force. But it's an interesting, ATVs are interesting because it requires the landowner's permission to ride an ATV in this state. So the landowner actually owns the land underneath these public easements. So there's some conflict there in statutes. I think there's a possibility, this is a tough issue, but I think we are not going to solve every issue around this. it's just not solvable. These aren't all solvable. But I think there are probably some things that might make it better. I think that's what we learned from the last group when we put together. We had 14 issues. We said, okay, where can we agree? Where can we make it better? The bill you just voted on isn't solve every problem, but it moves something forward. And if you can do something that prevents making more mistakes and causing more problems going forward, that would be, frankly, a success. If you decide to put a group together, I'd be happy to be a participant, knowing that this is not an easy issue.
Okay, fair enough. Thank you. So what is the wish of the committee? Is there a motion? Does anybody wish to make a motion? Representative Matlack?
I don't know about a motion, but I'll go along with Representative Toole about holding on to this going forward and seeing if over the summer a group that is put together to discuss these issues that are within here could come to some sort of an agreement. I don't want it to, again, as I was with the earlier bill, I'm not an attorney. I'm not interested in solving individual property rights. I'm interested in solving bigger problems. So I don't, if this is about a litigious issue, they could go to the courts. I think it's inappropriate for them to come to the legislature about individual property rights issues. But if Representative Toole thinks that we can work on this matter for 6 months and perhaps come to some sort of an understanding of the best way to move forward with this, I could do that. But obviously it's been worked on for quite a while, and I'm not sure that I know where something like this will go. But if Representative Toole is interested, I'll support his interest.
Okay, fair enough. Representative Toole?
Yes, and I thank Madam Chairman, thank you for that. I'm interested for the simple reason, 2 years ago, when we took up the Abandoned Roads Subcommittee, I was totally 100% against it, didn't see the value of it, wasn't really looking forward to it, got drafted into being put on it, got into it, and discovered that there was some common ground. And even if we do nibble at the edges of some of the issues, we may, as Mr. Doak said, be able to move something forward. And I know there are ongoing issues with the discontinued roads. And I think if maybe 5 of us were to, if we had a subcommittee of 5 that could be authorized to meet during the interim with some of the same stakeholders and others to see what we can come up with. I'm not saying there's going to be an outcome, but I do think, and the other part of that is with 596 going through, with the other bill going through, there may be other issues that come to light between now and then that we would want to, with this, try to work on and do a good job of.
So are you asking that this be tabled?
I'll make that motion, yes.
Okay, is there a second? Second. Informally, if we want to set up a subcommittee.
There's no discussing a tabled motion.
Okay.
Just needs to be
Cheryl,
tabled.
call the roll.
LD 1513, table motion. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
Yes.
Representative Randall Greenwood, yes. Representative Sean Paulus, absent. Representative Francis Head.
Yes.
Representative Francis Head, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. That's 10 yes to be tabled and 3 absent.
Okay, Representative Tool.
Now that it has been tabled, I do think in the past, if the committee, the process is we request a subcommittee of the committees through the presiding officers, permission to meet during the interim. Certainly could be done remotely or in person or whatever the situation allows. But generally the chairs and leads ask for volunteers. We have Lynn write a letter, and then we're granted the subcommittee, and we go on our way and meet 3 or 4 times during the off session and possibly into the next regular session. So I would encourage folks to be, if there are folks that are interested in serving on a subcommittee, I would certainly encourage them to step forward offline.
Okay. Is that Representative Copeland? You have your hand up.
Yes, I'd like to step forward online. I'm very interested in this issue and I'd like to be on that committee. I don't necessarily think that I need to take up one of the 5 spots. So maybe we could put it out to 6 or 7, but I'd very much like to be on this subcommittee.
Okay.
If I might cut in briefly, it has to be, a subcommittee can't be a majority of the committee, if I'm remembering that correct, but I think it has to be less than a majority.
Yeah, I don't think they'll be tough to, I'm sure we'll be able to find a place for Representative Copeland to serve. So is it the wish of the committee to set up a subcommittee as described? I mean, do thumbs up or hands or whatever? No? Do you want a formal vote, Lynn? Or a motion?
If I may, Mr. Chair, you would need to have a motion to take this off the table to have a discussion of a subcommittee. So perhaps at a later date, I can put this back on the calendar with perhaps the other bills that you're going to talk about to carry over. And you can have that discussion then and make a decision in light of all the other potential carryovers.
Great. Thank you very much. Okay, so that is the 3 roads bills. And the next one, are we doing Senator Kimes next? Is that correct?
Sir?
Yeah, go ahead.
I understand from Representative Toole that Senator Kime would like to hold off on this bill. She's in discussions with Representative Reisman with regard to an amendment on this bill that they haven't quite completed, and she would like until Wednesday to do that. So Representative Toole could probably explain better than I.
Sure, go ahead, Representative Toole.
Yes, thank you, Mr. Chairman. Thank you, Madam Chair. So to bring everyone up to speed on it, myself, Senator Kime, Representative Reisman have a variety of amendments floating around, and to complicate matters, Senator Kime has been traveling and is on the road today and would like a couple of extra days to work out, see if differences between hers and Representative Reisman's amendments can be worked out in the interest of moving this forward. Certainly would not want to move it forward indefinitely, but just a couple of days and then we could take it up again on Wednesday if folks are willing.
So do we need a tabling motion? No?
I think you just, because you haven't opened the work session yet, I think you can just say it's been rescheduled.
Okay. So we're going to reschedule this to Wednesday at 10 a.m. Is that correct, Representative Toole? Is that what you're saying?
Yeah, I was just lapsing there as to what time we start on Wednesday, but yes, Wednesday would be great.
10:01 to be exact.
10:01. There you go. Well, thank you.
Okay, so Lynn, what is the next item we're doing?
Thank you, Mr. Chair. 434 was on the schedule, and I did have an email from the sponsors that I sent to the sponsor, Representative Danny Martin. I don't know if you've had a chance to
Yes,
look at it.
I've seen that, and just so I'm sure people got the message. They just want us, they thought we had done too much work on this bill and they want to kill it now. And they find it unfriendly. I think that sums it up pretty much where it is. So yes, Representative Ann Matlack.
Thank you, sir. I'd like to make a motion of ought not to pass on this bill.
Hey, is there a second? Yeah, that's Representative Dorr. Lynn, did you want to have any comments on this, or?
I just wanted to say you would want to do a motion to reconsider first and
Yeah.
then a motion ought not to pass. Thank
Okay.
you.
Motion to reconsider.
Okay, Representative Dorr, do you second that? It's been moved and seconded to reconsider. Everybody in favor of reconsidering? Okay, let's see, now that it's reconsidered, it's back on the floor. Is there any discussion? Okay, Representative Matlack.
I make a motion of ought not to pass.
Okay, is there a second? There's a second. Is there any other discussion? Oh, Representative Greenwood.
Yeah, I didn't see the email that you're referring to. Obviously, I was a minority report on this bill, so I couldn't vote. I didn't make a motion to reconsider, but was there any comment from them as to whether they liked my minority report before we kill this bill?
I think they preferred your minority report. I think that was clear. So to be honest with you, I think they preferred your minority report.
Would there be any interest in moving that forward instead of killing the bill completely?
Yeah,
Those particular counties that may find it useful.
Representative Matlack.
The request from the sponsor was ought not to pass. I don't know what the other folks might be interested in, whether the representative from the counties was of the same mind, but that's what the sponsor asked us this morning in his email.
So just to refresh everybody's memory for the record, your minority report was to, why don't you restate it? So we're all clear on the record.
Yeah, so my minority report was to allow them to do it, but it required a 2/3 vote of the commissioners and a 2/3 vote of the budget committee. Even if the budget committee was advisory, it would require a 2/3 positive affirmative vote to move it forward. They still had the option to do what was already in statute. This would just allow them the one time, and they couldn't have more than one bond at a time. Lynn, was there anything else?
No, Representative Greenwood, I think you have adequately described your minority report.
Right, right. So I will probably sign on to that minority report just because I think that we should do something to help the counties, but that's just my 2 cents. Does anybody have any questions about the minority report? Okay, so we have a motion to ought not to pass as amended, I'm assuming, right, Lynn? Or just ought not to pass?
That's correct. The minority report can be decided after the vote.
Yeah, no, but the motion is ought not to pass.
Pass, that's correct.
Amen. Okay, great. So Cheryl, if you want to call the roll.
LD 434 ought not to pass. Senator Joseph Baldacci.
No.
Senator Joseph Baldacci, no. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
No.
Representative Randall Greenwood, no. Representative Sean Paulus, absent. Representative Francis Head. Representative Francis Head.
I'm trying to unmute. It's just, it's not that complicated, but it seems to get complicated before I can get the unmute. And I'm going to go no.
Representative Francis Head, no. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. 7 yes, 3 minority, and 3 absent. And the minority is ought to pass as amended.
That's,
Mark.
that's correct. Yeah.
Yeah.
Okay. We're making some progress here. Is the next one 1228?
Yes, it is, Mr. Chair. And I believe, I'm going to check the participants. I believe that Sheriff Troy Morton and Major Brian Scott are in the waiting area. So this bill is brought to us by Representative Bryant. The title is an act to promote transparency and public safety when public servants request towing services. But as you'll recall from the public hearing, the bill was amended and it is a different bill. So this bill requires the Department of Public Safety and the county sheriffs to develop and maintain a centralized data collection of towing and roadside assistance on what are called non-consensual tows. And that's when the owner of the vehicle is either unaware, unable to, unaware that this is happening, otherwise unavailable, car accidents, cars left parked places where they're not permitted is, I think, the 2 examples that come to mind. You heard quite a bit of testimony on this. This was to promote transparency and through the use of data. And it's with state and local and not transportation, because the original title and the bill that was drafted out of the revisor's office dealt with Central Fleet, which is a SLG subject matter. So that's why it's with you here. There were quite a few towing companies that came and testified in favor. They talked about, they mentioned how this has been a topic of discussion for many years and there hasn't been satisfactory progress in their mind. They are interested in transparency when the state police and the county sheriffs are calling and using different towing services, an issue of fairness. There were some claims that not all law enforcement are acting in an unbiased manner. And there were some questions about standards for towing companies, and there was discussion about how they are required to have a license to drive those types of vehicles, but there aren't any statewide standards that apply or professional standards that apply to the provision of services. The opponents with the Maine State Police came and talked about how this bill was a reduction, a compromise from what was originally being asked for by the towing industry. And there was discussion by Major Scott about the need to upgrade or amend the current platforms and computer programs that the state police use use on a regular basis, and how so there would be a cost because the current systems cannot track the data and separate out the data in a way that would make it readily accessible and available as required by the bill. There was quite a bit of discussion by Major Scott about the process that state police go through, the dispatch centers that are centralized, the public safety emergency nature of these situations. The Maine Municipal Association testified neither for nor against, and talked about how this would be a mandate on the county sheriffs, because that is not something that they currently do. And she also talked about, Rebecca Graham talked about how municipalities have the ability and often have ordinances or standards that they follow when hiring, when local law enforcement are hiring towing services. And the discussion was a bit about how it's more manageable on a local level to do that than it is necessarily for the state police or the county sheriffs when they're answering calls throughout the state. So I mentioned that that there is probably a state mandate attached to this bill because of its application to the county sheriffs. And the sponsor at the time during the public hearings asked that I add a state mandate, which I did. And as you know, if you add the preamble, the alternatives to a preamble is to get 2/3 vote of the legislature in favor of the bill or to add some funding. There were information requests made and the Sheriff's Association was asked to attend. And as I said, Sheriff Morton is here and he will be able to provide any answers to questions you may have about what the Sheriff's Association, how they operate, what they think of this bill. There were questions about if there's example of municipal ordinances. There were questions about whether there was an ability to determine the cost of the state police. And there were questions about the qualification and standards on towing companies. And I think I mentioned before that there aren't statewide standards on the provision of services. And I think that is all I have for an analysis. I have the bill that I can share again if anyone would like to see it.
With the amendment?
Yes, with the amendment, the preamble.
Yeah. Why don't you share it again?
Okay. So the mandate preamble is the first paragraph. It's fairly standard language. Actually, it's very standard language. So the bill is the same as the one that Representative Bryant shared with you, except for this first paragraph.
Okay, any Representative Copeland, you have your hand up? I think you can take it down.
Thank you, Mr. Chair. I did ask if there was a way to find out from LexisNexis, who is the platform that the state uses for their database. Was it did we have any information on having a module added for this information, or I'd like to hear about that.
Thank you, Representative Copeland. I was not able to make a contact with the company to get that information. I don't know if someone else who contracts directly with them was able to do that, but I was not able to find the person to answer that question.
Well, welcome, Sheriff Morton and Brian Scott. Thank you for joining us today. Do either one of you want to make some comments about the proposed legislation? Yep, go ahead, Mr. Scott.
Thank you very much, Senator Baldacci and Representative Matlock. My name is Major Brian Scott. I represent the Maine State Police and the Department of Public Safety. So I did have an opportunity to spend a little bit more time having conversations with Director Brody Hinckley. This was directly in relation to a request that was sent to him regarding Representative Copeland's question on LexisNexis. So I had mentioned during the public hearing a couple different vendors that we use. So LexisNexis is the main crash reporting system. That's a different system than the Spillman computer-aided dispatch system that we use. So Spillman would have been the company to contact regarding that, which could have resulted in some difficulties. However, Director Hinckley and his staff did have some follow-up conversations in-house, as well as reached out to Spillman. Spillman is in the process of trying to prepare a presentation to give to us on how we may be able to do this. But due to the time constraints here, we haven't been able to have that demonstration yet. However, this morning I met with Director Hinckley and his staff, Their belief is that there is a type of ad hoc querying capability that none of them have used, that they haven't been trained to use, but they believe that they may be able to extract the majority of this information, or some of the information anyway, without experience in it. They don't know exactly what it would look like, but they do believe that they might be able to extract some of the data at the end of the year so that we could provide some type of log or report moving forward. What I will say to that is we don't know what it will look like because nobody has any experience with that as of yet. Additionally, there's some staff time that it would take. So our position remains that we would be imposed. We're opposed for the reasons that there is no public safety nexus that's been associated with the request that's being made. And the state police has a lot of other priorities throughout the year. So as we voluntarily engage to do ad hoc reporting and querying and other types of things for industries and other folks or stakeholders, it does pull us away from some of our other primary duties. But I wanted the committee to be aware that I believe that we could accomplish it without a fiscal note, and leave it in your capable hands to make a decision on what you'd like to do. I will also say, though, that it's just the Department of Public Safety and the 3 regional communications centers, and they dispatch for the Maine State Police and some other state law enforcement agencies. We have no connectivity or connection with the Maine sheriffs or other law enforcement agencies as it pertains to towing logs or records or dispatch or any of those functions. So my response is exclusively for the Maine State Police.
Thank you, Major Scott, and thank you for your service. Are there any questions for Major Scott? Okay, seeing none. Sheriff Morton, did you want to? Oh, I'm sorry, Representative Matlack, you have a question?
Thank you. Yes, thank you, Mr. Chair. Really quickly, Major Scott, you mentioned that there could be a report for stemming from one of the modules or one of the an aspect of the currently used reporting form. Would that be a report out annually, or could this be a place where the information that had been talked about, where is my vehicle, what towing company has my vehicle, is it possible that that is what could be inputted, or is it just something about how regularly individual towing companies are used over the course of a year?
Oh, thank you for that question, Representative Matlack. So the state police currently collects that data. And if somebody like a vehicle owner or an operator of a vehicle called the state police and asked, we would be able to take a look at a particular date in a particular location. We can already provide that information to them as to where their vehicle was towed, when it was towed, what officer asked for it to be towed. So we have that capability now, and we do that on a regular basis. This report would be a sanitized report at the end of the year that wouldn't contain things like names, personally identifying information for the calls. It would just have like maybe the trooper's name, a date, a location, and a towing company that was called, so that we would be able to, again, have a log at the end of the year. Don't know how user-friendly it would be because we have no experience with it, but we believe we could extract that information. And we think it would probably be upon request. If it was this committee's pleasure and it was, an annual report to state and local, that would be something we would need to know so that we could prepare to have that presented to your committee by a certain date every year. Or if it was that, we would make that available by way of a FOA request if the department received one, where we would prepare that on a regular basis, maybe at the request of the towing industry or the Towing Recovery and Association of Maine or something along those lines.
Thank you. Representative Toole.
Thank you, Mr. Chairman, and thank you, sir, for your presentation today on this. My question would be along the lines of how much time and staff time, training, that sort of information do you think would need to be dedicated to put into that report and such? In other words, are there hidden costs that we might not be aware of at this time?
That's a great question as well, Representative. So in having conversations with the director, his thoughts were, for starters, if there was going to be a mandate, we would ask for maybe like a July 1 or January 1, 2022 or something instead of 90 days after adjournment. That way he and his staff would have time to work on it and wouldn't have to consider things like overtime in order to make this happen, where they would have a few months opportunity to plan, pick away at it, try, to run some reports. Once they figured it out themselves, then they would be able to train staff. The statement that he made is he believed that they could use existing resources to do this if in fact they had some time frame that was more than 90 days after adjournment.
Okay. Let's see, Sheriff Morton, you've been very patient, so thank you for coming. Do you want to share your comments on this pending legislation?
Thank you, Senator. Believe it or not, I feel like I have more experience in this field than I do managing the difficult challenges of the jail. This is a very, very competitive business, and I understand why this was brought forward. Separately, I have to separate myself as Penobscot County. I'm here, Sheriff Troy Morton from Penobscot County, but also President of Maine Sheriffs. So on behalf of the Maine Sheriffs, I would say that tentatively we have to oppose this. One of a couple of reasons. One is not all sheriffs are in charge of their dispatch centers. Some of those are controlled by other county operations, and some fall under the commissioners, some fall under the directors, and they're not under the direct control of the sheriff. So for that reason, many of the sheriffs wrote in this weekend, indicating that we would have to oppose based on that. They would need to be part of the conversation as the directors or the commissioners who run those facilities. Aside from that, if you want my experience of Penobscot County, we actually have this system already in place and have for many, many years. And reason being is because it has been a tremendous challenge. They're a very competitive business. We utilize the Spellman system. Much of what you're talking about on recording and reporting, we've been doing for probably 10 years. And so we have a lot of experience in it with the Spellman, but not everybody uses Spellman. I think just a little over half of the county sheriffs utilize the Spellman system. Not to get into details, but if you're interested, I could share some of the challenges that we've faced here, building rotations, and all the complex issues that come with that. While it's a challenge, we've been working on that for years, but it presents a tremendous amount of challenge. I understand that Representative Bryant's bill here is much more defined. He's really just looking for a report on how that takes place. And again, the sheriffs had to oppose really because we're not the ones totally in control of our dispatch centers. So we felt it would be not appropriate for us to comment.
Okay. Representative Bryant, did you want to weigh in?
Yeah, I think also you might want to bring in Mickey from the audience, where she represents the towing companies, and maybe have all three of them in the room at the same time. And the towing companies are the ones that brought this bill forward, so they're interested to be heard.
Yep. Cheryl, you want to do that?
On our way.
Okay.
I will say, while you're waiting, if I could, Mr. Chair, is that
go right ahead.
Major Scott has been extremely helpful, and even on his vacation, he's been emailing and trying to work it through. We also had 2 Zoom meetings with all people we could get together, and we have been trying to work on this in a way that maybe we come to some resolution. So I want to say that it's been a good discussion, but I would like you to hear from the towing companies if you choose, Mr. Chair.
Yes, absolutely. Thank you. Ms. Tebow, welcome. Good morning. You've been listening to the conversation. What would you like to add to the conversation?
I just want to say that I know this portion of the bill that we've revised may not solve all our problems, but it's the first step. Transparency is the first step to be able to determine if there is a problem. Up until this point, we haven't been able to access the right information, and I feel like we've gotten nowhere, kind of treading water. Like I said in my email that I sent a few of you, I would like nothing more than to dispel any rumor that there is favoritism or preferential treatment from towers. We're not against, law enforcement. We just want to make sure that things are fair, and we haven't been able to resolve any issues because of this whole unable to access information. We're willing to work with anyone that we can. We just simply want transparency, and so we can get ahead of it and not feel like we're not making any progress to our towers and their concerns.
Okay. Any members of the committee wish to add anything? Does anybody wish to Representative Toole?
Thank you, Mr. Chairman. Could we hear from Rebecca Graham on the concerns about how this may conflict with local ordinances or local situations, if she's still with us?
Ms. Graham, good morning. Why don't you tell us what the MMA's viewpoints are on this bill?
Thank you, Senator Baldacci. Responding to Representative Toole, right now this does not affect municipalities. I sent Lynn some of the ways in which municipalities do approach this on the local level, and that includes establishing ordinances that towing companies who want to provide their services for the city, both with law enforcement and parking issues, meet certain criteria, meet certain response requirements as well, carry certain levels of insurance or have certain equipment available for them, and also have predictable bills so that there isn't a sudden charge or a non-disclosed charge. Those sometimes are often in statute as maximums, which I assume also probably get updated on a regular basis. So it's just one way in which I had sent Lynn information that it could be approached to address some of those issues previously. But as far as reporting, we would probably be even in a more complex situation than the state police or counties are at this time as well, because of the nature of our data systems at the local level.
Yeah. So you don't see this bill as affecting local municipalities, correct?
No, our only concern would be the burden that it places on counties, which end up getting paid through municipal tax assessment.
Fair enough. Representative Matlack?
Yes. I think this bill gets us close to resolving an issue, and as Ms. Tebow was talking about, making it crystal clear that favoritism plays no part in detailing towing trucks to different incidents or being used in certain capacities, and that there is a way with little to no cost, but with just a bit of training, that the state police could do this, and that it is also maybe the ability of the counties to also do this. So I'd like to make a motion of ought to pass as amended.
Okay, Representative Bryant?
I do feel that we've gone as far as we can, if I can say. And if the two bodies, this gets approval of the committee and comes out as ought to pass as amended, one, I'd like to put like January 1st date to start or something reasonable in your amendment. Secondly, I think if it's obviously going to have a fiscal note, and that's why we didn't put all the municipalities in, because not to coordinate that, it is going to probably take millions of dollars to get a system that would work in time. But I know that Donna Doris disagree with that. But anyway, I would like to see it pass. If the two bodies, the Senate and the House, decide 2/3 a vote that it's good, more power to them. I've told them from the beginning that it's going to be an uphill climb. I can't see it happening. But if this is the best we can do with the time we've had, I think we should send it out to the body and let them see what they'll do. And if it doesn't get the 2/3 vote, then it will die, and that'll be the end of it for this round.
So is your amendment to have a start date of January 1st?
I would check with Lynn to see what more reasonable, at least at minimum January 1st, but what is normal, Lynn, at this time of the stage to put a start date?
Thank you, Representative Bryant. Would this be a date for the sheriffs and the state police to have the data available? Would this be the date that they start collecting the data, or a date that they send it back to us? Right now, there's no provision that they give state and local information.
It is my feeling, you're right, that this would be the date that they need to start, because they'd have to put a system together, which they may already have, but they've got to put a system together, start on the 1st, and maybe have a report to us. We'd like to hear how it's worked. So have a report maybe by April to the committee or something, you know what I mean? So they report back on how they're doing. That
Okay,
makes sense.
Hold on, I got a number of hands up. Representative Greenwood was first, and then Representative Dorr, you're next.
All right, thank you, Mr. Chair. I struggle with the bill because it looks like it's going to require a significant amount of work. What I thought sounded good was when Major Scott mentioned that he could, generate at year end a report, just of the overall activity, and I think that could be done relatively easily, and he indicated within existing resources for the state portion. And I guess I struggle with, we have 16 counties that all use different platforms, and to intertwine them into this mix, I wouldn't be supportive of that at all. Make that an optional report should they want to provide it, but if we could direct the Department of Public Safety to provide an annual report so that they don't have to respond to individual FOIA requests, weekly, monthly, yearly, quarterly, just an annual report, I would be satisfied with that. But other than that, I can't support the bill as it is.
Okay, Representative Dorr, you're next.
I was just wondering, and please excuse my chemo brain here, if that information could be more easily gathered if they took the accident reports, not the state police accident reports, but the accident reports that the individuals file. Because they have to be filed in 48 hours. I don't know, I'm assuming state police or sheriff or local police have to file in a similar time frame. Just trying to think outside the box, and maybe that would not push all that extra work on law enforcement if it could be easily captured through data that we're already gathering.
Okay, well, we'll keep that thought in mind. Representative Reisman.
Thank you, Mr. Chairman. I'm thinking that this bill, the way it's currently constructed, has come a long way from the beginning. It was first talking about the Central Fleet, and second of all, I'm thinking this should be a resolve for a study, not an act to put something in the statutes at this point. So I'm going to be voting against.
Okay, Sheriff Morton, you had your hand up. Thank you for being patient.
No problem. I apologize. I know it's not really my position to step in here, but
no. We want you to provide information.
Only having again a decade of doing this, it's a little more complicated than simply pulling this list together. Representative just made a great point about the accident reports, but many cars aren't towed during crashes, and that has little to nothing to do with it. It also has a huge issue on owner request. We should never impact owner request. That's a major difference. The capabilities of tow services, logistics of where tow services are, and their capabilities. The pricing issues is a huge issue amongst record companies. I think that's what stirs up many of this. There are many levels, and I say this with all respect and material comments below, we've actually met with the Tow Association when we developed our processes years ago, and it's taken a long time and they're tweaked often. I understand the concept of the bill. You want transparency. We actually provide local tow companies. I actually think if we ever get there, these could be done locally and send those to the tow companies themselves. I'm not sure why we're tying up legislative time to look at a report to say that we're reporting out on how many times you've seen it. We provide those to our local companies upon request to say how many tows they've had and when they've had them, and as part of the rotations. But I only share this out of again, of working with our local companies here. I think I have about 16 or so tow services, and there's a lot to this to make sure that we're transparent and that it's fair and equitable treatment to all. But it's not always apples to apples, and recording the data, if we're going to have data, it needs to be good data so folks understand. And as the committee, wherever this goes, we're happy to, at some point, we weren't brought in on this until just this weekend. So I have a lot of information here that we could share down the road if the committee heads in that direction.
Okay, Representative Bryant.
Again, I just want to make sure that everybody knows that, again, it's just non-consensual tolls that we're talking about, not the whole array. And it's just with the county sheriffs and the state police. So it's pretty limited in the scope of things, but it's still complicated.
Representative Toole.
Thank you, Mr. Chairman, and thank you, Sheriff Morton. Your comment about how you've been doing, did I understand you've been doing this for 10 years, or it took you 10 years to put a system together? And if the former is the case, how long did it take you to put a system together and refine it and get it to the point where you're at? How much did it cost?
Sorry, Representative. We've had our system in place for more than 10 years and maybe a little bit longer, but we've had to continue to adjust it as we've gone along. The needs are important. Representative Bryant's point is valid, very valid, that making sure that we know that these are non-consensual, that they're, parts of criminal investigations or subjects just aren't there with the vehicle, not owner request one. So again, inside that's broken down into a lot of different variables. It may be a criminal investigation tow, but the tow company might not be have the capabilities. They may not have proper storage indoors or outside, such as things as fatal motor vehicle crashes. Our policy, we have about a 10 or 12 page policy specific to this to show tow services having the capability to store a vehicle inside, those type of things. So again, it's a little complicated.
Right, and I appreciate that. I was wondering how long it took you to come up with not just the process, but from start to finish, how long did it take to come up with a system, and how much would that have cost just for your county?
Well, we're fortunate in Penobscot County that we actually have the module inside of Spellman. While people may be able to get that module, it is a cost. As everything, there's the Spellman system. They sell a module to everything that they add on, and County owns the license, so we provide that to all municipal and obviously the sheriff's office here in Penobscot County. But again, that's not all counties use Spellman. I think the other one's IMC, and I'm really not familiar with their system. It took us a while, 6 months, a year, but the module was in there. It does take training. It does take another log entry. Really, the most work is maintaining those rotations. If you don't have a rotation, it's not a real way of producing that report. You have to have a rotation. So get to Representative Bryant's ultimate question is, if the companies aren't a part of the rotation, you're not able to run a report to show XYZ company had 3 tows or 5 tows. And then also logistics of where you are. Our tow companies in northern Penobscot County are going to see far less tows than you would down where it's very populated in the greater Bangor area. So that impacts them as well.
Okay, Representative Copeland.
Thank you, Mr. Chair. So what I'm hearing is that there is a process for those who have the Spellman system to have a module and to make this happen. You've been doing it for 10 years. So sounds to me like that would lessen the learning curve for those others who have that same system. And I'm wondering from Ms. Tebow, she has said that she hasn't been able to get this information, but I'm hearing that it's readily available. I'm wondering what her perspective is on that.
Okay. Ms. Tebow, you want to respond?
Yeah, I have not tried myself personally to get the information. It's been, I don't know if Dana Layton is in the waiting room or not. He's the president of TRAM, and I know that we've been trying to get this whole process worked out. And I know that there are some counties that don't have a rotation, and that's probably finding that out is why we're not able to get the information. Because it's not in Penobscot County, it's more down this way. Like I'm in Durham, so that would be Androscoggin County, Cumberland County. So I guess I don't really have the right answer that you're looking for that question. I just know that we need the information there and be able to request it, because I've heard from members of the directors of TRAM that we have not been able to access this information in certain situations.
Okay.
May I follow?
Yes, go right ahead, Representative.
Would an annual report suffice?
I think it's a great starting point. If that's all that we are able to get, then absolutely. It's just we need to be able to dispel or prove or unprove any allegations out there. And that's definitely a good place to start.
Thank you.
Thank you.
Okay. Thank you, Representative Copeland. Any other comments? So we had a motion by Representative Matlack and a second by Representative Bryant. Representative Matlack, Representative Bryant indicated a start date of January 1st. Is that, or I think there was a colloquy, right, Lynn, regarding start dates? If you could just refresh our memories.
Yes, thank you, Mr. Chair. I believe Representative Bryant proposed an amendment that would instruct the sheriffs and the state police to begin collecting data on January 1st and to provide a report back to the committee in April 2022, so January 1st of 2022, and a separate amendment would be the report back in April of 2022.
Okay.
I'll accept that friendly amendment.
Okay. Thank you, Representative Matlack. Representative Toole, do you have something new to add to the conversation?
Yes, I thank you, Mr. Chairman. So as we know, the next legislature ends in mid-April of next year. So that April report back might be problematic in the sense that we won't be here when we get it reported back.
Okay, well, that's the motion on the table. So unless somebody wants to amend their motion, it's up to them. Representative Bryant, did you want to respond?
You're on mute. I would say April 1st. We want to give them a couple months. Obviously, the state police and the sheriffs could start as soon as they wanted to and get it worked out. But I want to make sure it's fair that we need at least a couple of months to see what they're doing, and then we could see if other legislation would come in for the next round. But we need some data to look at that over the following summer.
Okay.
So we said April 1st, just so that I want to give them a couple of months. I hope that and I know they will, and some of them, like some counties, as Mr. Morton has said, already have a system. And Brian Scott, Major Scott, has ways to at least get some data out now. If they refine that to what we're asking for, I think a couple of months data and anything generously want to give us before that would be helpful to see where they're at and see what's needed, what new legislation may be needed for the next year coming. But at least your start. If
if again, we'd get the 2/3 to move it through to cover the mandate that's there.
Okay, any other? So
To amend it to, my friendly amendment would be to report back by April 1st.
right. I think that was understood by Representative Matlack. Is that correct? Okay. Okay, seeing no other questions or comments, I'm going to ask Cheryl to call the roll.
LD 1228 ought to pass as amended. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
No.
Representative William Toole, no. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
No.
Representative Randall Greenwood, no. Representative Sean Paulus, absent. Representative Francis Head.
No.
Representative Francis Head, no. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
No.
Representative Walter Reisman, no. Representative Kathy Downs.
No.
Representative Kathy Downs, no. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. 5 yes, 5 no, 3 absent.
Okay, I guess we'll see how that comes out. Okay, thank you, everyone.
Can we just clarify?
Yeah, go right ahead.
I think I'd be speaking for myself, but I don't know which way it lies, but my report would be ought not to pass.
Okay, and what about the others? Do they want to give a thumbs up to that, or?
Same here, yes. I'm sorry, I spaced out yet again.
Yeah, that's all right. So it looks like a thumbs up that's the other report. Okay, so the next item I believe is 1340. Is that correct?
Correct.
Okay. And that's Representative Greenwood's bill. Lynn, do you want to start the analysis?
Yes, thank you, Mr. Chair. So this bill, which is Representative Greenwood's, is an act to ensure municipal compliance with federal immigration laws. It adds, are you seeing an email or a bill analysis?
Bill analysis.
Thank you. Wanted to make sure you didn't get that email. So this bill adds a new section into Title 30A. That says it revokes the general purpose aid for local schools, municipal general assistance funds, and state municipal revenue sharing funds to any municipality that has a law, policy, or procedure, formal or informal, that either violates 80 USCA section 1373 or prohibits local law enforcement from gathering information on citizenship or immigration status of an individual. This bill, when Representative Greenwood testified, he was fairly clear that this was not an anti-immigration bill. This was a bill, and his quote was, "This, we are a nation of laws, not of men." And he talked about how he did not think it was appropriate for local units of government to disregard laws that are on the books. There were several opponents who testified, the mayor from Portland, a former sheriff, the ACLU, and the Maine Municipal Association, to name just a few. There was a lot of discussion about two main points were that this would be contrary to the home rule concept, and also would negatively affect law enforcement's relationship with the communities. There was also a discussion about the fact that detention by ICE does not require probable cause, and that local law enforcement in the state generally are required to act when there is probable cause. And there were some written testimony that was also provided. There have been bills in the legislature in the past that are similar or a bit more expansive than this bill. They have in the past, I believe, all been with the Judiciary Committee. In the 128th, there were two bills that prohibited restrictions on sharing and using immigration and citizenship information. You can see by the votes that they were fairly close votes, ought not to pass and ought to pass as amended. There were two in the 129th, the 129th. They both died in committee. They were actually exact opposites. One was prohibiting government entities from restricting use and sharing of citizenship and immigration information. And the other was prohibiting law enforcement from stopping, detaining, investigating based on citizenship and immigration status. And so those were a little bit on opposite ends of the spectrum, and those both died in committee. There is another bill on immigration that is still with Judiciary. They voted to re-refer, but it has not come to our committee yet. So I don't know the status of that. I'm sharing with you. So as I said previously, this bill ties certain funding to law enforcement's or policies and procedures with respect to two things. And one of them is tied to this section of federal law, which talks about communication between government agencies and the Immigration and Naturalization Service. So this section of law has been deemed to be an unconstitutional infringement. It is contrary to what's called the anti-commandeering doctrine, which says that Congress shouldn't be giving instructions to states, and that the US Supreme Court said that the anti-commandeering doctrine applies with equal force to federal statutes which tell states to enact certain types of laws, and federal statutes that tell states to refrain from enacting certain types of laws. And it is the refraining type of law that this section of federal law was doing, and that was found to be unconstitutional. So my general comment would be, from a technical perspective, the committee may not want to keep the language in this bill that refers to that section of federal law, but that would still leave in this bill the provision. So the provision that ties funding to policies and procedures that local entities and governments have about law enforcement gathering information. So it's not a fatal flaw. You can strike the provision of this bill that relates to this federal law if you so choose, and there's still language left in the bill that ties funding to actions and inactions by local law enforcement. Let's see. I think that's the only matter for consideration that I would raise with this bill. And I believe I included, but didn't include with this bill analysis, a separate document at Representative Greenwood's request. He wanted information about the amount of funding. I can share that with you in a moment if you're interested in seeing the breakdown of the types of funds that this bill applies to, but I won't share unless asked. And are there any questions about this bill?
Any questions? Okay. Representative Greenwood, did you want to respond to any of the analysis?
Yeah, thank you, Mr. Chair. I would ask Lynn at the conclusion of my comments to share the requested analysis, which was the educational funding, on that sheet that she provided. A lot of the opposition that I heard from at the public hearing was regarding, that we're going to have the Gestapo come in and, round up all these people. That's not the intent of the bill. The intent of the bill is, with general assistance, which is public assistance, it's merely a question: are you a citizen? Do you qualify? That can be easily asked and answered. that portion can be, because those are, yes, there's some local dollars, but there's a significant amount of state dollars tied with those general assistance. The other program with education, it's merely just a simple question upon enrollment, which you have to enroll every year in public education, is, are you a citizen? And if you're not a citizen, the taxpayers shouldn't be funding your education. It wasn't meant to be a very controversial bill. It was just a matter of making sure that we're in compliance and we're only providing state tax dollars that are funding people who are lawfully allowed to be here. And that was, I didn't mean this to be an anti-immigrant bill, which that's appears the way it's been taken. But that being said, I would ask if Lynn could share that document with the committee.
Yes, thank you, Mr. Representative Greenwood. So the general assistance column is the second, then education funding, and then revenue sharing, and it has multiple years. 2021 is at the very bottom. So general assistance, this is total distribution to municipalities, was 14,534,000. Education funding was 1,343,000,000, I'm rounding, and revenue sharing was 127,770,000. So that is the funding dollars total across all municipalities and counties.
Okay, any questions?
Mr. Chair, can I follow up?
Yes, go right ahead,
Yeah,
Representative.
and I just want to emphasize that those columns that were just provided, that is the state portion. In dealing with general assistance, that's 14 million. Municipalities are on the hook for 50% at the beginning, and then as the threshold rises, they go to a higher percent. Same thing with education. There's local education dollars that aren't included in those numbers. Those were the state numbers. And again, my only point is, the taxpayers of this state should only be providing tax services for people who are legally allowed to be here. And that's my point. Thank you.
Okay, just to be clear, I have a question, Lynn. As I read this bill, the way I see it is that it doesn't require local governments to ask about citizenship, correct?
No, it does not.
And it doesn't require the state to ask about citizenship on any documents, is that correct?
No, it does not.
All it does is that if a municipality adopts a policy that prohibits the gathering of information, just trying to formally
Yeah. If you take out the reference, taking out the reference to the federal law, what would remain is that if a municipality has a law, policy, or procedure that prohibits law enforcement from gathering information on citizenship and immigration status, then the funding, those three funding sources would be removed.
Okay, so the 8 USCA section 1373, but that why don't you tell us exactly what that prohibits? Because that's different from the entirety of this law.
Yeah, so let me pull that up again. Yes, so that is a specific set of provision in federal law that, as I said, has been that is this provision right here that courts have found to violate the anti-commandeering. So this says that a state and local government may not prohibit.
So this section has been found to be unconstitutional?
It has not made its way to the, it has been found unconstitutional, specifically this provision, by a variety of courts. It has not made it to the US Supreme Court, and that's why I included this.
Okay.
this anti-commandeering language that comes from the US Supreme Court.
Okay.
So it's questionable. And because it's questionable, that's why I raised it to the committee.
Right.
And I believe that even if you take this out, I believe that the representative's intention still remains with the remaining language. He may have a different opinion, but I believe his intention still exists.
So is there, other than that 8 USC, is there other statutory duties at the federal level for municipalities to cooperate?
I don't know the exact answer to that. I do remember that Rebecca Graham, when she was talking about this, talked about how local law enforcement generally do not enforce federal laws. And I don't know who made the example, but the example was given of the fact that marijuana is now legal within the state of Maine, but it's still a violation of a federal statute. And that was to the point of the general principle that generally local law enforcement deal with local laws. But I don't know specifically the answer to your question about whether there's other obligations that the feds place on local law enforcement.
Okay, Rebecca, do you want to weigh in on that?
Thank you, Senator Baldacci. I think there would be probably a number of ways, including restrictions to information that is shared with local law enforcement by federal authorities. Some of the databases that law enforcement access are restricted to law enforcement only disclosure. So within the immigration context, were there to be an immigration hold on an individual, even at that point, law enforcement must seek notification from that federal agency that they are going to pay and actually deport or take over that individual before they could be detained. It's not something that's actionable by local law enforcement as a hold alone. So there is that interface there. And there's also a responsibility for some of that information that law enforcement receives from federal agencies to be restricted specifically to law enforcement. So they couldn't even share that within other municipal departments.
Okay. So any other questions or comments? Is there a motion? Representative Greenwood?
I would move on to pass.
Okay. Is there a second to that motion? Okay. Is there a second? No? Oh, okay. Representative Matlack? Did you have a motion?
Yes, I'd make a motion ought not to pass.
Okay.
We have heard testimony from many areas around the state that this would be a bill that is contrary to standard procedures, accepted local ordinances, and the way that we live life here in the state of Maine. And I do not wish us to go down the path of enacting a piece of legislation that is, as it stands, contrary to federal law, and I believe would ruin many relationships within our cities and our communities. And I also am not happy with the conflation of people living in this state who don't pay taxes when they do pay taxes. Just because they may not be permanent residents as yet, that does not mean that they don't pay taxes and that they should be vilified as folks who are not carrying their own weight here in the state of Maine. And so I will be voting ought not to pass on this one.
Okay. Representative Dorr, did you wish to speak as well? I know you seconded it. Yep. You're still muted though.
Can you hear me?
Yes.
I cannot wait until we're in that big gray building across the river so we can see everyone in person and get away from that damn mute button. I just want to say yes, I am seconding that, but I just think it's so important that we all remember that everyone in this committee, everyone that you meet every day, we're all from away, and that's all I have to say.
Okay. Any other questions or comments? Okay. I just want to say for the record that I'll be voting in support of ought not to pass. But I would also say that if we had if there was a community in Maine that was found to have violated federal immigration policies, then I would be inclined to sanction that community, because no one has a right to be above the law, regardless of what some may say or how some may feel, that we have an ultimate duty to abide by the law until the law gets changed. But I don't feel this is narrowly tailored. I do think that the federal statute needs to be clarified by the U.S. Supreme Court one way or the other before we start weighing into this, because it could get even more complicated. But I think, it just needs to be said that no community can put itself above the law. But I'll be voting on not to pass on this, and I appreciate the sponsors' efforts. And I appreciate the whole committee's efforts to debate this and, put together our best arguments. So Cheryl, if you could call the roll.
Yes, LD 1340 ought not to pass. So if you say yes, that means you're voting for the motion ought not to pass. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole. You're on mute, sir. Representative William Toole, you're off now.
Is this thing working? I was going to
Yep,
second
we can hear you
Representative
now.
Greenwood's motion, but I can't get my computer to work. So,
Oh, okay.
So be that as, I'm a no.
Okay, thank you. Representative William Toole, no. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
No.
Representative Randall Greenwood, no. Representative Sean Paulus, absent. Representative Francis Head.
No.
Representative Francis Head, no. Representative Donna Dorr.
Yes.
You need to be visible, please, ma'am.
Sorry, whoops. Wait a minute. Oh, my goodness. I was cheating and having a snack, but I'm here.
No snacking. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
I'm starving, by the way. Can I vote yes?
I'm sorry, could you say that again, please?
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
No.
Representative Kathy Downs, no. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. 6 yes, 4 no, 3 absent.
Okay, and the minority report. Representative Greenwood ought to pass. Ought to pass. Yep.
Straight.
Yes, I believe so. Yep. Okay, I know people want to are getting hungry, but we only have two more bills, right? Okay, so I believe the next one is the People's Reviser. Is that correct, Cheryl?
It's 1515, yes.
Okay, Lynn, do you want to?
Yes, thank you, Mr. Chair. So this is an act to create the People's Reviser. I think I saw the Secretary of State's office representative in the waiting room, but they may have left. And I don't know if Representative Sylvester is here, but this is Representative Sylvester's bill. Let me
Well,
share.
I see Julie Flynn is here.
Yes.
So we should let her in.
Okay.
So this bill creates, or excuse me, this bill requires the revisor's office on request to consult with and provide drafting assistance to persons involved in either initiating a people's veto or a direct initiative of a bill. and provide drafting assistance to individuals involved in local referenda. The sponsor talked about how drafting legislation and bills and initiatives is an art form, some would say, and that's providing support to people in their use of the democratic process should be promoted. The no opponents or proponents, the Secretary of State's office did speak, as did the League of Women Voters, neither for nor against. And the Secretary of State's office spoke about how current law already provides support to the people's veto and the direct initiative situations. And the League of Women Voters of Maine spoke about the reviser's office as a limited resource. So I have in front of you what comes out of Title 21A and confirms what the Secretary of State's office said. So a people's veto referendum or a direct initiative does require an application to go to the Secretary of State's office. The people's veto is based on a bill. So that language has already been worked on by the reviser's office. It is also reviewed by the Secretary of State. The Secretary of State in a people's veto drafts the ballot question. So the people promoting the people's veto have the Secretary of State and the reviser's office input through that process right from the beginning. The direct initiative, the Secretary of State's office also reviews that language and revises if necessary. The law provides the Secretary of State may reject a direct initiative if it doesn't conform to drafting conventions established in the Maine revised statutes. And the current law allows the Secretary of State to request the assistance of the reviser's office in reviewing the proposed direct initiative. So I believe that the Secretary of State's office was correct that there is language in current law that applies to people's veto and direct initiatives. It does not address what was also in this bill, which is providing assistance when people are drafting local referenda. And I believe that would probably be the work of the municipal clerks or municipal officers in assisting in that process. But with respect to the statewide people's initiatives and vetoes, there is language in the statute that involves the Secretary of State and the reviser's office as needed.
Okay. And Ms. Flynn, welcome. Would you like to make any comments? I read Secretary Bellows's written testimony. Did you want to make any additional comments?
Sure. I mean, good afternoon, I guess, or almost good noon. Representative Matlack in committee, Senator Baldacci in committee. The people's veto application just has to reference the law that they are seeking to keep from taking effect. And we draft the ballot question and then provide a petition form with the language that already was passed by the legislature and that the people are seeking to prevent from going into effect. With the initiative, they do have to bring us more than a concept draft. So they couldn't say, we want to change the process for, I don't know, registering vehicles. They'd have to give us some language where they would like to amend and the changes that they would like to make. And it doesn't have to be in perfect form because that's when we send it over to the reviser of statutes and they will put it into the proper format and ask questions of the proponents to make sure that the legislation is drafted the way that they want it. So they're not getting assistance up front, they're turning something in, but then it is working through the reviser's process to get that into the proper format if the proponents want to make those changes. So That's all I have to add, but I'm happy to answer any direct questions.
Okay, thank you very much, and thank you for your service. Any questions? Representative Greenwood?
So is it in your opinion that this wouldn't be necessary because it's already available?
That's right. We do have a website that gives some information, and we send out packets to people who request it, and giving sort of the step-by-step, but we're happy to talk to people about the process if they need some additional assistance before they submit their application.
Okay, Representative Matlack?
Thank you, Mr. Chair. Good afternoon, Ms. Flynn. Well, almost afternoon. So if somebody is putting together a petition that they would like to put out for signature around the state, they would write something and submit it to you, and you would polish it up, or the revisor's office would polish it up. Is that how it works?
That's essentially correct, yes.
Okay.
The law says we can deny an application, but it would only be if they put a very vague, concept without giving us any idea of the statutes that they want to amend or add. So they've got to give us enough that the revisor can work with it and put it into the right format for them.
Okay, thank you.
Okay, Representative Toole.
Thank you, Mr. Chair. Am I on? I'm having issues with my computer, so.
We can hear you and we can see you.
Okay, then my question.
That's all we ask.
Sometimes that might be too much. So my question for Ms. Flynn was essentially, if this, well, actually, it was more along the lines of, so after these petitions go through, get their signatures, even if there is an issue, then they come to the legislature, we have a chance to, we can adjust them, and we passed legislation last year to require a public hearing in most situations on these type of things. Is that correct? That's correct, isn't it?
Representative Toole, if you were to amend, when we certify the signatures and we send it over to the legislature, your option at that point is to pass it exactly as is,
right,
or perhaps send out a competing measure.
Right, that's what I was getting at.
Yeah. And those would both go on the next ballot as part of the same ballot question.
Right.
But you can come back in a later session and amend something. At least at this point, you can come back in a later session and amend something if you need to tweak something afterwards.
No, I thank you for that. That's what I was getting at, so that there already are checks and balances in place in the current situation.
Did you want to make a motion, Representative Toole?
I can, yes. I'll make a motion about not to pass.
Okay, is there a second?
I'll second that.
Okay, it's moved and seconded. Any further discussion? Just for the record, I would note that the Secretary of State had noted in her testimony that it would be preferable to offer information in writing and also classes. So to the extent that her office can do that, obviously we would encourage it. But other than that, I think that we have a motion and a second. So Cheryl, call the roll.
Yes, LD 1515 ought not to pass. So if you say yes, you're going with the motion, ought not to pass. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Tool, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
Yes.
Representative Randall Greenwood, yes. Representative Sean Paulus, absent. Representative Francis Head.
Yes.
Representative Francis Head, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. 10 yes, 3 absent.
Okay, thank you very much. Thank you, Ms. Flynn, for being here. Appreciate it. Okay, our last item is LD 1522. You want to go ahead? Ann?
Thank you, Mr. Chair. LD 1522 is another bill by Representative, oh no, I thought it was Sylvester, but it's not. It's Representative Dudera. This is an act to update and eliminate references in statute to the word alderman, selectman, and overseer of the poor. And I'm gonna share my screen with you all. And Board of Selectmen would be replaced with Select Board. Selectmen with municipal officer, overseer of the poor with overseer, and alderman with municipal officer. So this bill, the sponsor talked about the need to update language, both with the municipalities have a desire to update their language in their ordinances and other documents, but there's a concern that their updates would conflict with the words that are used in state laws. There was a discussion about how many of these words are not gender neutral. And a Professor Carolyn Ball testified in support, as did the Secretary of State's office, in the importance of eliminating gender-based language and archaic language. There was some discussion that there are some issues with the some of the specific amendments and proposed substitutions. For an example, there was a word defined, which the definition used the word in the definition. So that's generally not considered the best way to create a definition. MMA also testified neither for nor against, in favor of some of the ideas and not in favor of others. And they proposed an amendment which had quite extensive revisions. Generally, when we get bills of this type, I do a word search through statutes to see how many times these words appear. I can say that the word alderman appeared maybe twice, maybe 3 times. The selectmen, board of selectmen appear quite extensively, as does the words municipal, municipal officers, municipal officials. They are peppered throughout statutes, and I may have come up with 150 statutes that have those words, but that does not mean the word only appears once. Within those 150 statutes, some of these words may appear multiple times. So the point I'm making is that revising these words is a very, very difficult to do, only because you don't want to create unforeseen situations and make things worse than they are, particularly when definitions are in one section might be referenced in another section. I did not have a chance to reach out to the revisor's office to see how extensive of a review they go through. If this bill were passed, the revisor's office goes with a fine-tooth comb and looks at all the use of these words and the cross-references of these sections to make sure that there aren't any errors and or omissions. Generally, they do not do that level of work when it comes to an initial draft. It's just the press of business. So I would expect, if this bill were to move forward, that there may be some questions that do come up that I would need to bring back to the committee on specific changes. But as I said, I haven't talked to the revisers about that. And I do know that, and I'm sorry, I'm playing with my mouse and I'm sharing the screen, so I apologize for that. But MMA did provide some extensive amendments that I have on the screen and that I sent to you. And that was their proposal. I did not go through, and I have not done that time-consuming task. But if the committee moves forward with either the original bill or the amendment or some combination, that would be the work that would be left to do.
Okay, any questions for Lynn? Representative Matlack?
Thank you, Mr. Chair. My question is for Lynn. I understand that Maine Municipal had an extensive amendment or suggestions for how to handle some of these language changes. Was that the second part of what you were showing us?
Yes.
Page 2 and onward was the Maine Municipal amendment?
Yes, thank you, Madam Chair. And I'm sorry when I included this with my bill analysis, I didn't give it a title, but everything from this page on is the MMA proposed amendment that was submitted during the public hearing. So yes.
Thank you.
Okay, Representative Toole.
Thank you, Mr. Chairman. So if Rebecca's still here, could we get a nutshell summary? Is this simply changing Board of Selectmen to Select Board and changing Select Man to Select Person? Is that generally the change that's being made? So it's more of just it's more of a technical wording change as opposed to a definition or referencing type of thing.
Lynn, do you want to respond to that, or
No, Rebecca.
I believe it was for Ms. Graham. Thank you.
Thank you, Senator Baldacci. Representative Toole, that's correct. We also removed some of the problematic language that confused municipal official and municipal officer sections that were part of the original bill. So we struck them out with more appropriate language that realm to avoid some issues that may come up as a result of the differences between charter communities and select board communities. And we just tried to keep each one of those gendered terms into something that was more neutral. We also kept alder person in because we haven't had the time to go across to figure out how much or how often, or if there are any communities that are still referring to that. It may be completely archaic, but we didn't want to strike it out entirely, not knowing. So we just changed that to alder person as part of that. And that may be able to be struck out entirely at some point as well.
Okay. Any other questions or comments? Is there a motion on this bill?
Make a motion to pass as amended. And also Representative Dudera, who's the sponsor of the bill, is here. I was wondering if she thought that the amendment by MMA covered all of her requirements for this bill.
Representative Dudera, welcome. Did you want to add anything to the discussion?
Thank you very much. It's nice to be here. Thank you, Senator Baldacci. Yes, I want to thank Ms. Graham for her work on the amendment. I think that it's great. And I also just wanted to add that we also had input from the Secretary of State's office, and that they were, this was something that they were in support of doing this updating. So thank you very much.
Thank you for your work on this bill, and thank you for being here. We appreciate it very much.
Hello,
What are you doing?
I'm on Zoom meeting.
Okay. Okay, I don't know where that was, but that's fine. So who would like to, so do we have a motion ought to pass as amended, Representative Matlack? And do we have a second?
Second.
Okay, it's been moved and seconded.
Who seconded? I'm sorry.
Representative Dorr.
Okay.
Okay, and I think we're all ready for a roll call.
Okay. Senator, LD 1522 ought to pass as amended. Thank you, Representative Dorr. Thank you. Senator Joseph Baldacci.
Yes.
Senator Joseph Baldacci, yes. Senator Kimberly Rosen, absent. Senator Ned Claxton, absent. Representative Ann Matlack.
Yes.
Representative Ann Matlack, yes. Representative William Toole.
Yes.
Representative William Toole, yes. Representative Mark Bryant.
Yes.
Representative Mark Bryant, yes. Representative Randall Greenwood.
No.
Representative Randall Greenwood, no. Representative Sean Paulus. Absent. Representative Francis Head.
Yes.
Representative Francis Head, yes. Representative Donna Dorr.
Yes.
Representative Donna Dorr, yes. Representative Walter Reisman.
Yes.
Representative Walter Reisman, yes. Representative Kathy Downs.
Yes.
Representative Kathy Downs, yes. Representative Lynn Copeland.
Yes.
Representative Lynn Copeland, yes. 9 yes, 1 ought not to pass.
Ought not to pass.
Okay, thank you. And 3 absent.
Okay. Thank you, Representative Dudera, and thank you, Rebecca Graham. Thank you, Julie Flynn. I think that we have successfully concluded our work for today. Lynn, did you have any other issues to present to us?
I have 2 very quick issues.
Oh, make them
2
quick.
They are. I feel your pain. They are.
No, I'm just teasing. Go right ahead.
These are, I'm going to share one fiscal note and then another fiscal note.
Okay, great.
And these are the committee voted, so I will do these slowly. So LD 131, which is an act to amend the governor's emergency powers. And Representative Greenwood, Head, Toole, and Senator Rosen and Representative Downs voted ought to pass. And this is the bill that, so it was a straight ought to pass, and there is a fiscal note. So I am hoping you're all going to nod your head and say, yes, you approve changing your vote from ought to pass as amended to incorporate the fiscal note. I'm going to stop sharing so that I can see you nodding your heads. Anyone? Okay, great. Similarly,
no one disagrees, so I think that was
okay. And let me get the next one ready. The next one is a fiscal note for LD 1441, which is an act to create a James Weldon Johnson Annual Observation Day and an observation task force. And the individuals who voted ought to pass include Representative Head, Bryant, Toole, Matlack, Senator Baldacci, Senator Rosen, Representative Reisman, Downs, and Copeland. And again, this has a fiscal note with a minor general fund cost. And this is cost for the State Museum and the Maine State Archivists to serve on this task force on the Permanent Commission on the Status of Racial and Indigenous and Maine tribal populations. So does anyone object to changing your vote? Anyone that I named from ought to pass as amended to incorporate the fiscal note?
Anyone objects, please raise your hand. See, okay, Walter Reisman, you raised your hand.
I don't think he's objecting though.
Oh, well, what are you, Representative Walter Reisman, did you want to say something?
I'm for the fiscal note.
Okay, okay. If you want to raise your hand to object, I don't see any objections. Okay.
Thank you, Mr. Chair, that is all I have.
Okay, so we will be convening at 10 a.m. on Wednesday, correct? Okay, and
That's-
is there a motion to adjourn?
No move.
Moved and seconded. Have a nice day, everyone. See you Wednesday. Thank you.